This matter is a contempt matter, Lordship. Will no Lordship against the Dibrugarh University, Lordship. As a pensioners, they are the pensioners, Lordship. Lordship, in the last on 21st of July, Lordship has categorically directed that money has to be released to the petitioner. But 1 month has elapsed, Lordship. Nothing has been done, Lordship. So I'm praying for the matter to be listed on Friday, Your Lordship.
Monday.
Lordship.
Monday.
Monday, Lordship. Not so blessed.
Yes, please, Lord. My Lord, I am mentioning a matter for listing for hearing, my Lord, for the prayer of the governing body. I am for the governing body of college. Now, what happened, my Lord, it's a matter of 2018, my Lord. In between, my Lord, 2 insurance principal has already retired. The petitioner is challenging the selection of the principal. Now, college is without a principal, my Lord, for last 5 years, my Lord. Now, my Lord, this present insurance is going to retire, my Lord, in September, my Lord. So, my Lord, this matter, my Lord, may be taken up on 31st of August, my Lord, for hearing, my Lord. Obliged.
I have a similar prayer, Lordship. This is 2015 matter. Several times listed and your Lordship has had this matter. The person is retired in the year 2015. Lordship, may I pray, Lordship, this matter may be taken up on 1st September. On hearing day, Lordship. On a hearing day. 30th. Okay, 31st.
May it be your Lordship. Lordship, there is a matter for listing on Friday, my Lord.
Why
For motion, my Lord. Kindly bit, my Lord, sir. Some appointment process is going on for a provincialized teacher, my Lord. For that process only, my Lord. Otherwise, some other will get the appointment, my Lord. Obligement.
May I please, your Lordship, I am going to mention 2 items. One matter, my Lord, this is pertaining to the appointment of a president of SMDC. This matter may be heard on 29th of this month.
29 will be difficult. We'll have it on 30.
Yes, my Lord. And second, my Lord, this is the in-charge headmaster, my Lord. And headmaster is going to be retired. So this matter may be heard on 11th.
When is he retiring?
Oh, no. Oh, no, their stay is in favor of me, my Lord. Our Lordship has already heard the matter. And
13th September.
13th September.
My Lord, these matters relate to compassionate appointment, my Lord. This may come up for motion, my Lord, tomorrow, my Lord.
Not tomorrow.
When
Monday.
on Monday.
May I please, Lordship? I beg to mention item number 24 and 45 because kindly matter may be adjourned for a week, my Lord.
You are for petitioner.
Yes, my Lord.
Your good name, please.
K. Kolita.
K.
K. Kolita.
On request made by K. Kolita, Leonard Council for the petition. Please the matter after
After a week, my Lord.
a week. Item 24.
24 and 45.
Same order.
I'm so glad.
May I please, Lordship? I beg to mention one matter to be listed, my Lord. There is contempt matter, my Lord. It is contempt
30.
May I please, your Lordship? May I please, your Lordship? My Lord, I am praying for listing, my Lord. Since 1 year, my Lord, the case has not been listed, my Lord. Next week, any date, my Lord.
7th September.
Obliged.
May I please, your Lordship. Your Lordship, I beg to mention item 25 with the consent of the other party.
Have we given your mention slip?
Your Lordship, mention memo is still on the way, means it's one of my colleagues is bringing, actually.
You should have given it yesterday. Wait for your turn.
Okay.
May I please, your Lordship? I'm praying for listing of writ petition tomorrow, Lordship. The matter pertains to the selection list of the MBBS students, Lordship. A similar case is listed tomorrow, Lordship, before your Lordship.
May I please, your Lordship, I beg to mention for listing of 2 writ petition for order.
Okay. 13th September.
Obliged.
Lordship, I filed a writ petition on Monday, my Lord. Let it be posted for motion on Friday.
No. 30.
May it please, Lordship. I beg to mention item number 7, my Lord. Kindly taken up next week, my Lord.
Have you given your slip?
Let I
Mention slip.
I'll give, my Lord.
No. Wait for your turn.
Yes, my Lord.
Lord, may I pray for listing of a pending writ petition pertaining to recruitment in the post of teacher. We could not apply because of the age bar, my Lord. and we applied for age relaxation that was not considered. We challenged that order, my lord. But if it is not disposed of at an early stage, my lord, my right to apply in the particular post will be, my lord, infructuous. So if I may pray for listing of the matter next week, my lord, any date.
7th.
Much
Lordship.
obligation.
Lordship, I beg to mention WBC 3225/22 listing on 29th August.
13th September.
30. August. Thank you, Mr. Malati, I is for in connection item number 27, that may be called for my.
May it please your lordship, I beg to mention for listing upon WPC for motion by next Monday,
30.
30. Yes.
May I please your lordship, I beg to mention for listing of the matter in admission. This matter is relating to compassionate appointment.
15th September.
That's all.
Please, your lordship, I beg to mention item 29.
Uh,
Kindly the matter be adjourned till next week, lordship.
Wait for your turn. You've not given your mentions yet.
Motion.
May it please, your lordship. Matter is regarding suspension, my lord. Petitioner is subject teacher in a higher secondary school, and he has been suspended on 13th of March 2023, my lord.
Page.
Base is that, my lord, 22.
Uh, Yes.
My lord, what happened, my lord? The petitioner has been suspended without giving any statement of allegation and show cause, my lord. And my lord, already 5 months has gone, my lord, and till that no statement of allegation has been received by the petitioner. And my lord, rule is very much clear, my lord, as per the, my lord, Assam Service Manual rule, my lord. The charges and statement of allegation should be served within 3 months from the date of suspension. So my lord, till that no statement.
Yes,
of allegation.
Yes, my instruction is over phone, lordship. I have that so cause is yet to be issued, lordship. It is not yet been issued.
And the suspension order has been reviewed.
Let not be reviewed. That
That
is my our telephonic instruction that I have in the morning, lordship.
you get written instructions.
But that is what I am saying, lordship. If I get the
We'll
written.
take it up on Monday.
Yes, lordship. Yes.
Third MS.
P. Goswami.
P. Goswami, Learning Council for the petitioner. List the matter on 28th August to enable Mr. S.M.P. Christie, Learner Standing Council, Secretary.
Oblige.
Obliged.
Go.
Lordship, matter regarding recovery of excess royal lordship. On last occasion, instruction was sought for lordship.
Yes, Christie.
Here, lordship. Lordship. That instruction I don't have, lordship. May kindly take it up after some time. Let me get the instruction over phone, lordship.
No, please, your lordship. In this case, lordship, the respondent number 3 has filed his affidavit in opposition. I will file my reply to that, lordship.
Malad, in this case, Malad, Lordship directed Malad to file an affidavit. What reply they will file? Lordship may hear me, Malad, for first of all, our affidavit.
Before hearing him, if I may say, if I may submit,
Issue notice. No, Malad, what happened, Malad?
because I would like
Stay,
to.
there
bring-
is not the stay order, because this is the distribution of certificate. Petitioner has failed. And now they parties, those who have passed, Malad, they are not made party. I mean, this was only today, Malad. Interim order was there. Otherwise, they were not getting Malad, the pass student. This is not a PL, Malad.
Before
So,
he,
let him file a reply. I have no any objection, but interim should not be continued. The interim will not help them. If they pass Malad, after scrutiny of the examination of the read petition, they will get the certificate. What interim was passed?
lordship, the mark sheet distribution was stayed. Your lordship has heard it on merit. This is the third time they have raised the issue of vacating the interim order. The interim order was passed at the motion stage.
So
At the presence, at their presence.
our distribution has been Malad stage, because the students are suffering.
This is the
Those who
third.
fail, they fail student, my lord. If they pass, they will get the certificate. No problem.
Lordship,
Others are not made party, my lord. This is not a PIL, my lord. That's why interim should not be continued. Let them pass, my lord, reply.
Have you not met them parties?
Now to make a party.
Lordship, they are not appointed, so they are not required to be
Appointment
made.
is not there. It is selection, pass.
And I would like to bring some certain new facts in the reply also. There are certain other questions against whom wrong answers have been given.
No.
No, that I will place on record. I have that. I have the proof also. I have verified it and I can place it on record. Lordship may kindly.
But
give-
what is the harm in letting them distribute?
Lordship, once, this is the third occasion, Lordship, they have raised the issue of vacating the interim order. Once the distribution is done and they will issue the advertisement for appointment to the post of LP teachers.
That will take time.
Yes.
But they are not saying
You
that,
file your reply within 1 week.
yes, Lordship, till then the interim may be continued.
no,
Because
I'm not continuing.
Lordship may kindly continue the interim because if they issue the mark sheet, because there is no time period prescribed by them that they will, within this and that period, they will issue the advertisement or they will issue
Once
the.
the advertisement is issued, then
Yes.
this court can stay the advertisement.
Yes.
But if they don't
Exactly,
issue,
madam.
if the contention which I will raise in the reply, if
That we'll see after you
Yes.
file your reply.
Let them file his
but
reply.
no one, not a single qualified candidate has
But
approached this.
they are not parties.
Not party, my lord.
But they have the full knowledge regarding the case.
No.
But
they
you are
don't know.
supposed to make them parties.
They don't know.
Lordship,
Now, without making them parties, how can I continue?
Lordship, there are lakhs of candidates who have qualified.
Yes, let them party.
So it is not possible for me to make them party
If this is
By
not
way of
possible,
representative capacity, you can make them parties.
because they are still yet to be appointed. So in
no
my proposal
appointment
submission
question appointment does not arise, my lord. It is only examination.
and the mark sheet distribution, Lordship, the mark sheet distribution will be done by the SSA. SSA has not objected to the interim order.
No.
Till
will
now.
say.
The SEBA has
Who
objected.
appears for the SSA? You are appearing for
SSA
SEPA?
party, yes.
Yes, we are conducting the examination, my lord.
They have
We are- we have to
conducted
hand
the
over the
examination.
mark sheet,
That
my
part is over. The
No,
SEBA
no,
part,
there is
that
no
is over.
advertisement at all.
SEBA has no role at all. After
Why
this.
not?
When are you filing a reply?
Lordship, within 3 days, I can file it. Within 3 days.
3
But-
days.
But interim should not be continued, my lord.
But Mr.
R. Bora, Lordship.
R. Boral and counsel for the- No. Mr. R. Boral, then counsel for the petitioner. Place for 3 days time to file reply. The counter filed by the SEBA.
Yes, Lordship.
Stop. Praise the Lord. This the matter again on. Today is what date? 23rd,
23rd, Lordship.
28th. 28th of September,
August.
August. Stop. The interim order passed today. Stands vacated.
Lordship may kindly continue the interim order because if they.
28 will see, that time nothing will
Yes,
happen,
yes.
heavens will not fall.
Our
Lordship,
affidavit has-
the same rule may be made applicable to them. In fact, heavens will not fall to them also. Because if they issues the advertisement, Lordship,
No advertisement, my lord. It will take some time, my lord.
not a single vacation application has been filed by the respondents, Lordship. The
But
respondent
then
number 3.
after considering the matter,
Yes,
after considering the matter, when you have not met them parties and this interim order is continuing, it's not. proper.
Yes.
That issue was not raised at
Let them distribute the marks, the,
If they
because
pass, they will get it.
if they issues the mark sheet by tomorrow, if they start distributing the mark sheet by tomorrow
What
and
the-
within 2 days, suppose they finish the distribution of mark sheet within 2 days and within a week before listing of this case, within a week they they issues the advertisement.
Let them.
If I don't
let them issue the advertisement, you bring that advertisement to the notice of this court, this court will stay the advertisement.
Yes, my lord.
Lordship,
Yes. Obliged, my lord.
can there be an observation to that effect, Lordship?
No, I'm not passing any observation, but if any advertisement is made, immediately placed before the
Yes.
court.
Secretary and advertisement to oblige, my lord.
Obliged.
May I please, your lordship? My lord, in this case, my lord, last occasion, instruction was called for, my lord, whether murder application was considered or not at point. At the relevant point.
I have the instruction, my lord.
From the instruction it says, my lord, though the matter applied, my lord, it was forwarded to the director of his, but it was not placed in the DLC.
That is the my case, my lord. Thereafter, my case is my lord, recommended by the PLC, my lord.
Firm's case was recommended
SLC,
and
my lord.
recommended to the SLC. And SLC rejected.
Rejected, my lord.
Where's your instruction?
So it was sent to the director of his department, my lord. It never came up to the DLC, my lord. So it is not clearly mentioned, but it is implied.
My lord, mother case was not considered, therefore, my lord, my case is considered, my lord, by the DLC, my lord.
Yes, your mother's case was not considered.
Yes, my lord.
She
Therefore, my
did
lord,
not agitate at any point of time.
my lord, therefore, my lord, my mother filed an application, my lord, page number 18, my lord. That I see. My lord. No, my lord, page number, that's very not. My lord, page number 26, my lord. To give my lord to me, my lord. Since my
In 2014,
yes, my lord.
when did your mother apply? 2002?
Two, my lord. Two, my lord. Since my lord, thereafter, my lord, lot of communication, my lord.
12 years, what was she doing?
My lord, page number, my lord, 22, my lord. This is forwarded to the director, my lord. Again, my lord, in the year 2008, my lord. In the year 2008, my lord, this is also forwarded to the inspector of school, my lord. Whenever I visited to the office, my lord, they said that your application will be considered shortly, my lord. I mean, withdraw, my
Yes,
lord.
2014.
Therefore,
Then
my,
when did you make your application?
in the year 2014, my lord, I made an application to the inspector of school. Since my application is not considered, my lord, my son may be accommodated to them, my lord. Thereafter, my lord, I applied, my lord, at page number 28, my lord. Petition I applied, my lord.
That was after 1 year.
Yes, my lord. Since my lord, mother application is my name is there, my lord. So, my lord, I formally applied to 2015 again, my lord, in the year 2021. My lord, one important letter is there, my lord. Page number 31, my lord. This is my lord government letter. Which instructed to the all deputy commissioner. Page number 31, my lord. Page number 31, my lord. Kindly instructed to all deputy commissioner immediately convey DLC with pending cases, if any, pertaining to case so department for incumbent who died on or before 31 March 2017, my lord. Thereafter, my lord, my case has been considered, my lord. After this letter, my lord, my case has been considered, my lord, by the DLC 28/12/2021, my lord. Page number 39, my lord. 39, my lord.
And your case was?
Page number 31, my lord. Assistant teacher, CL number 10, Pulokesh Gogoi.
Yes.
Yes, my lord. This is my lord for assistant teacher, my lord. Thereafter, my lord, my name was forwarded to the SLC for final consideration, my lord. SLC did, my lord, at page number 51. Since my lord, at that time of I was minor, my lord, that observation is there and some delay is there, my lord. Delays because, my lord, I have already told to the court, my lord, since my mother application is pending. And I was at that time I was minor, my lord.
That time when you're 17 years.
Yes, my lord. I'm spending years, my lord. So minor, I could not apply my
You make
mother.
your application at the age of 30 years.
No, since my mother application is pending, so my lord, I could not apply, my lord. I expect that my lord, my mother case will be considered. Since my mother case is not considered, my lord, thereafter I applied, my lord.
Yes, Begu.
So my lord, my simple pay is a human back to the SLC, my lord, for case consideration. Only I will Jaha or one husband also, my lord. On in the case of minor, my lord, at the time of death, my lord.
What is the?
My lord, this my lord 195 page number. So it Khadim Hussain, my lord, state of Bihar, my lord.
Where is the citation?
My lord, 2006 9 SCC 195. This is my says, my lord, at the time of minor will at the date of the evening.
This is a different issue.
Yes, my lord.
This is a different issue.
Yes, my lord.
Facts are different.
Facts are different, my lord, but the issue is just same, my lord.
These facts are different.
My lord.
It's not relevant to the.
Yes,
case.
my lord. So, my lord, my simple pay is that to remand back to SLC.
No, no. How can I remand it back?
Hello, oh, one important.
Your mother was sleeping, you were sleeping.
No, my lord, I was expecting, my lord, since my case will be
That
considered.
is
My
a
lord.
different.
My lord, one important the husband of our High Court, my lord, page number 69. No, my lord, page number 66. My lord, page number 66, my lord, sorry. Page number 66, my lord, division bench judgment, my lord. From 67, my lord. Same case, my lord, single judge, my lord, dismiss the rate petition. Thereafter, my lord, Honorable Court observed that DLC is the appropriate authority, my lord, to decide this issue, my lord. Hardship, delay, this type of issue, my lord. Accordingly, remand back to the DLC, my lord. In my case, my lord, DLC rightly observed, my lord. Accordingly, forwarded to the SLC, my lord.
This also is different. Here the DLC has considered your matter. In this particular appeal,
Yes, my lord.
it was not considered by the.
Yes, my lord, not considered, my lord. On the part of delay, also, my lord, this is not reactor in nature, my lord. Already, Lordship has observed, my lord.
No, no, these are all different facts. This
Okay.
does not cover much. You want to find some any other ruling, you can. I'll
My
give
lord,
you
I
that. Otherwise,
have known, my lord.
I'm disposing of this.
My lord, Lordship want to remand back the matter to the SLC.
I'm not remanding it back. I'm dismissing your.
My lord, then my lord, sometime may be given, my lord, I will. My lord.
On request by Mr. D. Gogoi and party for the. It's the matter after 2 weeks.
Hello.
File.
May I please your lordship? My lord, this is regarding compassionate appointment, my lord. My father died in 8/10/2016, my lord. Therefore, I have applied on 7/3/2017, my lord. But till date, the DLC has not placed and considered my case, my lord.
Yes.
The petitioner hears not enclose any evidence where matter has been placed before the DLC.
Not placed yet.
It has not been placed.
My lord, that the concerned department have to be placed before the TLC. My lord.
So who is the concerned department?
Education department. My lord. If on the petition,
My lord, in the next meeting, DLC may consider my case, my lord. This is the simple prayer, my lord.
it is.
Where's the application?
Page number 13, my lord.
Only the application is given.
Page number 12 onwards, my lord. 12, 13, 14. my lord.
17, simple. My lord.
Let it be placed before the DLC, Mr.
My lord,
Chairman.
department verify करोगे, कौन सा question है, करने का होगा। It is to by what, it is to place one, ना?
If not already placed.
Or it was submitted or not.
हाँ, तो this simple नहीं होता है। उन्हें technical लोग नहीं करते।
See, Chisti, if not already placed, let it be placed. If it is placed by the DLC and considered, let the outcome be communicated to the.
And the
petitioner.
inspector also verify whether he has properly submitted the application or not, because the receipt notice, the seal is not legible. And it was given to the inspector, and it's a free document, can you pay? Case 12.
I'm on page 12.
My lord.
Yeah, let it go.
Must go accordingly.
Heard, Mr.
FL Oscar, my lord.
If you last call on the council for the petition. Also heard Mr. SMT Chishti, the standing council. Secondary education for the respondents, 1 and 3.
Yes.
And Mr. B cycle,
My lord, for two.
government advocate for the respond number 2. Stop. The father of the petitioner. While serving as,
Was Hindi teacher of
where have Mr.
page number 3, my lord, paragraph number 2.
While serving as a Hindi teacher of Khukratuna Public High School, died in harness on 8/10/2016. Stop. Thereafter, petitioner met an application for appointment on compassionate grounds before the Inspector of Schools, KDC Karimganj, on 7/3/2020. Stop. It is the case of the petitioner that his case has not been considered by the DLC till date, and therefore being aggrieved is before this court. Stop. Considering the short, considering the matter, this writ petition is disposed of. Directing the Inspector of Schools, KDC Karimganj, respondent number 3 to place the case of the petitioner before the next immediate sitting of the concerned DLC. Stop. If not already placed. Stop. If the case of the petitioner has been considered by the concerned DLC, the outcome of such consideration shall be communicated to the petitioner for with the above.
Obligement.
And also verify whether that he was properly submitted this petition before the.
Let me-
DLC will consider.
6.
Please, your lordship, my lord, this matter relates the correction of date of birth of the petitioner, my lord.
Yes,
The
Seba.
peti- Yes, my lord. The petitioner had earlier approached this honorable court and there was a direction to
Who is that
reconsider.
order?
at page 44, my lord. Relevant portion, page 46. Para 7, my lord.
Yes.
And the respondent authority has rejected.
This is my lot, notice may issue, otherwise my lot petitioner,
Notice.
my lot, they say 85, they have appeared existential examination, and within 1 year, 86, they have submitted application, and that was acknowledged by a board of.
First, Mr. S.P. Chowdhury. No, MS S.P. Chowdhury, then Council for the petition. Issue notice. Mr.
This is here,
No, standing council,
Attorney Council,
Seba
Seba,
appears on behalf of the respondents.
1, 2, 3,
1, 2,
4.
1 to 4. Stop. Extra copies. Petitioner takes steps for service of notice on respond number 5 by registered person.
Obliged.
Respective office.
7.
May I please?
Yes, you wanted to.
Yes, minute. Some documents are left out at the time of filing, my lord. I have filed additional yesterday, my lord, bringing that report in this matter. So kindly taken up next week.
On request made by Mr.
R. Islam.
R. Islam, the council for petitioner, list the matter after 1.
Obligation.
Lordship, the item number 2, Lordship directing to take instructions. Lordship, I'm unable to connect the inspector school Lakhimpur. Let it come on Monday or Friday, Lordship, I'll get the instruction, Lordship, in the meantime.
Third, Mr.
Item 2.
S. Alam, then the council for the petitioner. On request made by SMT Chishti, then the standing
Monday,
council.
Lordship.
Standing council,
Secondary.
secondary education.
Yes.
This the matter on 30 September, August.
Obliged.
8.
May I please your lordship? Matter pertaining to compassionate appointment, my lord. DLC recommended me page number 22, my lord. And page number 27, SLC reject me on the ground of the service period was
Page
left,
22.
my lord 22.
Where's your recommendation?
My lord, serial number 2.
Jitul
Yes, my lord.
Katim Raj. Yes, then what happened?
My lord, SLC reject me on the ground that service was less than 3 years left, my lord. Page number 27, serial number 2.
Or it has deferred or declined.
My lord.
The committee has,
The committee has deterred the claim of the candidate as the remaining service period of the disease scoped employee is less than 3 years, my lord. My lord already closed one set aside. And I
when
have,
was this? When is the SLC?
my lord, SLC is page number 27.
Now, when was it held? 2/3/2023. Yes. Yeah, Peko. But MS,
M Das.
M does, then counsel for the petitioner.
I appear for respondent number 1. And my narration will appear for 20.
And also heard Mr. J. Bikul and the governor advocate for the respondent,
1.
one. And Mr. SMT Chisti and the standing council, secondary education for respondents, 2 and 3. Stop. The father of the petitioner, while serving as headmaster in Jumar Milon Bikyapit High School, now gone, died in harness on 17 to 2015. Stop. Thereafter, the petitioner submitted his application for appointment on commissioner grounds on 3/7/2020. Stop. Where's the first rejection order?
My lord, page number.
Where's the first rejection by the DLC?
23, my lord, page number. 2/3/2023.
No, 9/1/2015. Thereafter, in pursuance to High Court order, my lord, it was again replaced and considered.
Thereafter, the district level committee
Page number 19.
now go. In its meeting held on 9/1/2015. Rejected the case of the petitioner on the ground that the application was submitted. Deleted. Stop. The petitioner being aggrieved, approached this court by way of WBC number 1779 of 2022, which was disposed of by order dated 14/3/2022, remanding the matter back to the DLC of Nagaon for fresh reconsideration by taking note that the application of the petitioner is 3/7/2013 and not 3/7/2014. Stop. Thereafter, the district level committee now go in its meeting held on 39/2022, recommended the case of the petitioner for appointment on commission. Grade 4 post, isn't it? For grade 4 post,
My lord.
recommended the case of the petitioner for appointment on commission grounds to a grade 4 post under the inspector of schools, NDC, Nagaon. Stop. The petitioner's case was thereafter placed before the state level committee, which in turn, in its meeting held on 2/3/2023, rejected the case of the petitioner on the ground that the deceased employee within bracket father of the petitioner so that the remaining service of the deceased employee, remaining service period of the deceased employee within bracket father of the petitioner is less than 3 years. Stop. Well, clause 1 of the OM dated 1/6/2015 has been struck down by this court as being unconstitutional and being violative of Article 14 of the Constitution of India by order dated 31/2023, passed in WBC number 1646 of 2021. Stop. Para. In that view of the matter, comma, the matter is remanded back to the state level committee to reconsider the case of the petitioner afresh, keeping in mind that clause 1 of the OM dated 1/6/2015 has already been struck down by this court. Stop. With the above observations, directions, district.
Obliged, my lord.
9.
Made please. Lordship, here is a case of amalgamation of a MV school with a high school. Lordship, the concept of amalgamation, Lordship knows, has a statutory basis at section 28 of the 2018 Act, which contemplates there would be a scheme. The scheme would provide the process of amalgamation. Rightly, in August this year, last year, Lordship would find that scheme at page 16. A scheme has been made. The primary objective of the scheme that a school which have a low enrollment would be amalgamated with a school for maximum utilization of teachers. Now, my school, Lordship would find it at page 15, has 176 students. It had been amalgamated with a high school. Lordship, now, if Lordship turns to
You have how many students?
176, Lordship would find it at page 15. Last part, Lordship, the last line,
Yes.
176. For the year 2023-24, for the year 2022-23 also, it's 175, 21-22, it's 163. Now, Lordship would find at page 20, one of the conditions where an MV school would be amalgamated with the high school. Page 20, clause 11. To optimize the use of service of teachers of a 2-class high school, one nearby ME school having poor enrollment that is less than 35 students in each class may be merged with a high school. That is the, however, in hilly areas, Lordship, that is not applicable to me. That is one point. Ma'am, I have 176 students, it cannot be amalgamated. Secondly, Lordship would see page 21. Clause 70. There shall be one committee at the block level and another at the district level to find out the schools which are eligible for amalgamation merger in view of the provisions of the RT Act and the norms assessed. Now, Lordship will kindly come to the RT Act. Lordship will just kindly take the RT Act. From here, I want to point out two things, Lordship.
Yes, section.
Yes, the schedule of in the RT Act.
Did you?
Schedule. At the last phase of the RT Act, this is schedule.
Yes.
The scheme contemplates, Lordship, first, that if a ME school merges with the high school, there would be one headmaster of the high school and there would be no headmaster of the ME school. Now, Lordship would come to the schedule at next page, Lordship, from 6 to 8. The schedule starts point number 1B. Point number 1B, at least one a full-time where admission of children is above 100. Lordship gets it, that point. 1B, clause 3 of the schedule of the RT Act, where where admission of children is above 100, one full-time headmaster. That is the requirement under the act. The scheme has to function as per the RTA. Now, if this school is amalgamated, it will be violating the RTA Act. This is one reason. The second reason is there would be no school nearby MEMV school for more than 3 kilometers. That is another, Lordship would come to the rules now. There is a rules of the under the RTA, which says that there has to be a MV school within a radius of 3 kilometers. That is also violative of the RTA. Now, so this school under no circumstances can be amalgamated as per the scheme itself. Therefore, Lordship, I have challenged the amalgamation orders.
Where is the amalgamation order?
Yes. Lordship, firstly, Lordship, I have typed a copy at page 24. 25 is the original. In pursuance of the government office memorandum communicated by ASI dated 3/8/2021. That is the scheme I was showing your Lordship. And subsequently, per approval of the Secondary Education Department, so and so, the Director of Secondary is pleased to issue the order of amalgamation following schools of Bongaigaon district. The details. My school is at clause 18.
Your school is?
In clause 18, Lordship, Geruka Bari High School with Geruka Bari MB School. Lordship, after that, at page
So,
20,
high school is the best school.
yes. Now at page 27, there is another order issued for amalgamation and the process of amalgamation. That is also under challenge. Now, Lordship, though there is an appellate provision under the scheme itself, therefore, I preferred an application to the director stating these reasons. Lordship would find that at page 30, but it is not yet considered, Lordship. And at page 30, I have, in fact, the high school has a lower enrollment than the MB school.
I'll direct you to file the appeal then.
Yes, Lordship. Here lies the difficulty. This appeal has no receipt. Whereas he has actually filed it to the director, Lordship. There is no receipt, nothing, Lordship.
No. I have filed it on 9/8.
File and press appeal before the director as per clause 19, Lordship.
Lordship, till then, status quo will be maintained till my.
Any order passed by the director, appeal has to be filed before the secretary comes out,
There is already a
before
committee,
the
Lordship.
government. You filed the appeal before the wrong forum.
Maybe, Lordship, they are not so well
Unless
versed in
I'm
law.
wrong, is that appeal provision?
Yes,
Yes.
page 22, Lordship, clause 19.
Yes.
Appeal before the government is clearly stated.
They are not so well versed in law. But
And that is also, and there is no receipt, Lordship, whether the appeal has been
no,
filed
it's
before the authority or not.
it's received.
Yes. Heard Mr.
BP
B.B. Boral and the counsel for the petition. Stop. Also heard Mr. S.M. Learned standing counsel,
Yeah, both secondary elementary both are party, Lordship, for all the respondents, 1, 2, 3, 4.
secondary education. For the respondents, 1 to 4.
1, 2, 3, 4.
Para. The petitioner. Who is the petitioner here?
He is the president of the school management committee.
Who is the president of the school management committee of Hirukapari MB School? Is agree with the order dated 3/7/2023 passed by the director, Secondary Education Department, by which the Keruka MV school has been merged with the Keruka Bari High School, correct?
Yes.
On the ground that close eleven
11.
and 17 of the office memorandum dated 3rd August 2021 issued by the Government of Assam Secondary Education Department has been violated. Stop. It is the case of the petitioner that the Keruka Bari MV School has an enrollment of 176 students for the year 2023-24.
24.
Correct. And the said best school, and the enrollment of the said best school, namely Keruka Bari High School, has lesser enrollment,
Enrollment 160.
lesser students. Stop. Para. That much will do it.
There's a factual aspect that secretary will determine.
Yes.
Moreover, Lordship, there is no MB school within 3 kilometers.
It is also, the further case of the petition is that there are no MV schools within
The radius of
Within
3
the
kilometers
radius
as
of-
contemplated by the RTA.
3 kilometers as contemplated under the right of children to free and compulsory education act.
Rules,
The
rule 4. Rule 4, Lordship.
rules 2010. Clause 19 of the OM dated
3rd of August 2021.
3rd August 2021
Page 16. And 22 is just relevant.
provides for an appeal before the government in the secondary or elementary education department for any disputes arising out of the order passed by the director concerned. In that way of the matter. Petitioner is directed to file an appeal before the secretary school education department, Assam, within a period of
Lordship, 15 days.
15 days with effect from today. Drafted from the Secretary School Education Department on receipt of the appeal, shall consider the same and shall consider and dispose of the same after giving an opportunity of hearing to the petitioner within a period of
1 month.
1 month from the date of receipt of the appeal. Till the appeal is considered and disposed of
Only
by
thing,
the Secretary School Education Department. The impugned order dated 3/7/2023 shall remain suspended insofar
wait,
insofar
status quo should be given, because it is of
shall remain
1.5 months back, Lordship. July
insofar
order.
as the petitioner school is concerned.
Deeply
Status quo is suspended because Lordship, that
Deeply
may create some difficulty if in the meantime. Lordship.
In the above,
Then. Next, please, Your Worship.
Yes,
Similar to what happened, the deceased was Kumuruddin Ahmed. He died in harness, my lord. He was a school teacher. So he left the petitioner and his wife and pro forma respondents, my lord, as his heirs. Now what happened, my lord? The private respondent, my lord, number 10,
Who's private respondent number 10?
is wife of the deceased, my lord.
Oh.
He applied to the deputy commissioner, my lord. Applied to the deputy commissioner a certificate for next of kin, my lord. So, my lord, that next of kin certificate, your lordship will get at page 42. Let 42 next of kin certificate. Now your lordship will turn to 43, my lord. What she did, my lord, respondent number 10, page 43. That Rumi Khanam, respondent number 10, my lord. Page 42, next of kin certificate. Then, my lord, next page 43. Rumi Khanam. That certificate shown that Rumi Khanam is the only next of kin, that is legal representative of the deceased. So certificate was issued. And what she did, that certificate was produced before the authority. It's a completely illegal certificate. Because the petitioner before your lordship and pro forma respondents are the legal heirs, my lord, of the deceased.
Who are the pro forma respondents?
My lord, brother is there, my lord. That sister is there. All are direct descendant of the deceased, my lord. Now what happened, my lord? By suppressing all facts, this certificate has been taken by the respondent number 10. And thereafter, that was produced, that illegal certificate, my lord, suppressing all material facts, produced before the authority. And the amount about 3,79,000 has been withdrawn. She has got entitlement, my lord. As wife, she has got entitlement. But by producing a false certificate, my lord,
Are you challenging this next of kin certificate?
No, yes. No, my lord, I applied, my lord, till date it is not issued to me.
Are you challenging this next of kin certificate?
Yes, my lord, your lordship will go to my prayer.
No, there is no fair, Lordship.
Yes, there is prayer. There is prayer that this next of kin certificate may be cancelled.
Where?
Directing, your lordship will turn to page 15.
Oh.
And directing respondent number 5 to cancel the next of kin certificate issued to the private respondent number 10. So, my lord, my humble submission before your lordship, this certificate is completely illegal certificate. And what, my lord, what deputy commissioner did, my lord, without inquiring, local inquiry is necessary. Who are the next of kin? Without inquiry, my lord, she suppressed one thing, one aspect of the matter for her benefit. But deputy commissioner also failed to make an inquiry. Process is there. That after that application for next of kin, my lord, immediately matter will be referred to the Lat Mandal, and Lat Mandal will go visit the area and locally inspect who are the next of kin of Komaruddin. That was not done possibly. That will reveal from the record of the deputy commissioner or affidavit filed by the deputy commissioner what he did. Now, my lord, this certificate is liable to be cancelled. She is entitled, no doubt. But why this illegal certificate has been obtained by her? There is very wrong intention for wrongful gain. That is why, my lord, what she had drawn, my lord, she had drawn 3,79,000, about 4 lakhs already. Let it remain with her, my lord, after the final decision of the writ petition, what your lordship decide, whether that is recoverable from her or not. But further, my lord, further, no service benefit may be provided to her till disposal of this writ petition on the basis of this next of kin certificate. Because for getting benefit, my lord, next of kin certificate is necessary, and this is illegal certificate. So, my lord, further, no amount should be released by the authority, my lord, to her against the service of Kumuruddin.
Yes.
And she will not face any difficulty because she is also working woman, my lord. She's a provincial, she is a teacher of a provincialized school.
My lord, regarding the disbursement of amount, my lord, that will be department, my lord, after proper verification of the document, my lord, whatever submitted by the concerned claim, my lord. Here, my lord, case is that it is the service amount, my lord. There is a nominee also there, my lord. And if, my lord, this concerned person is, my lord, she is concerned about that money, my lord, he have to communicate with the department. And whatever document issued by the deputy commissioner, on the basis of that document, my lord, is has released, my lord. If there is any disputed in the facts of the next of kin certificate, my lord, he may send us before the concerned authority, my lord. Civil suit, by way of civil suit, my lord. Otherwise, this issue cannot be
My
determined,
lord,
my lord.
authority issues
Because, my
certificate.
lord,
Why we go for
even
civil
we
court, my
cannot
lord?
till now, my lord, until and unless this is decided, this is invalid, my lord. We cannot say that this document is invalid, my lord. We have to process, my lord.
My lord, let notary go to the deputy commissioner, whether it is a proper certificate or not, my lord. What my learned friend said that,
My lord,
and then,
verification-
my lord, every writ petition will be civil case.
Disputed questions of facts are involved.
My lord, disputed question of fact, my lord, disputed question of fact will come when she comes and say that it is genuine next of kin certificate. On the submission of my learned friend, that will not do, my lord.
Okay. heard
My
to
lord, in
Mr.
the report, my lord, we cannot.
M.A. Sheikh, Leonard Counsel for the petition. Stop. Who is the petitioner in this writ petition?
My lord, petitioner is son of one of the brother of the deceased, my lord. Brother died, my lord. Brother of the deceased died, leaving this petitioner only here, my lord. He is the petitioner before the Lord.
You are the brother's son.
Son. So brother is entitled. In the absence of brother, my lord, I am entitled. If anything goes to,
Where is that you have the pension rules, isn't it?
My lord, my lord.
Where is that rules?
Pencil note, my lord, nominee, first nominee.
Who is the nominee?
nominee is the wife, my lord.
Yeah.
Nominee is wife. I'm not on that, my lord. I'm not saying that she is not entitled to anything. She is entitled. But there should be some benefit, my lord, regarding pension. Pension will go to her. But regarding other service benefit, my lord, GIS, etc., my lord. So, my lord, that is to be shared with the.
How is it to be shared?
My lord.
Where is the provision?
My lord.
Where is the provision that it
No, my
has to
lord.
be shared?
Provision will look into, my lord.
No. We want to see the provision now.
My lord, now your lordship will consider whether on the basis of a illegal certificate, my lord. She is
Illegal
entitled.
certificate, how do you say when the wife is the nominee of the deceased government servant?
My lord.
Then
Well, that is there, my lord. I do agree. But thing is this, my lord, why she produced the illegal next of kin certificate? Where is the problem with her?
no, what does it say with regard to the pension and pensioner benefits this person? There's some rules, isn't that you have?
Yes,
some-
my lord.
What rules is it?
139 pencil.
1969 rules, my lord. Pension rules, Assam pension rules, my lord. There's a definition of family, my lord.
Is it rule 143?
Provide 143.
My lord,
Definition of
let it come on another day, my lord. I will examine this.
Huh?
Come
You
prepared.
better examine, otherwise this is a
Yes,
case of dismissal.
Yes, my lord. I'll see.
It says, family for the purpose of rules in this section,
Yes, my lord.
wife in the case of a male officer,
Yes,
husband in the case of female officer,
yes.
minor sons and unmarried minor daughters.
My lord.
No brothers, no uncle, no nothing.
Now, nobody is
no nephew.
included in the family pension.
No nephew, no niece.
I'm not on that, my lord. Family pension. Your lordship would be pleased to see. My lord,
Wife is entitled to family pension.
my lord, if it is not pension only, my lord, I have no dispute. that the private respondent number 10 will get the family pension. I have no dispute. I am not placing anything against her.
So what are
My submission before your lordship, family pension is one thing, my lord, and other service benefit is another. So there is a distinction, my lord. Let me examine, my lord, on another.
Okay.
Yes, my lord.
on request made by Mr. M.A. Sheikh, then counsel for the petitioner.
Right.
List after 2 weeks.
Obliged.
11.
Your Lordship may kindly pass over the matter for
Why,
time being.
why?
Your Lordship, my seniors is on like in court number 1.
Lordship may take up the matter at 2, your lordship.
You will see after.
Nice.
12.
May I please, your lordship. The case of compassion appointment also. Her husband of the petitioner died in the year 2003. And immediately lordship, this petitioner submitted an application before the lordship respondent authorities to consider her application lordship against the lordship genocide of her husband. Subsequently, lordship, the managing committee of the said school where this petitioner's husband was working as a Sokidar, they also lordship resort to lordship appoint this petitioner, and they also further resolved that they will lordship request the concerned authority to consider her application. Accordingly, lordship, this petitioner was allowed to work as a lordship Sokidar of the said school. In the year lordship 2005, the lordship, the district elementary education officer Nalbari issued an order lordship whereby this petitioner service was adjusted lordship against the expired vacancy of late Surendra Das. That is at page 24.
Two 2008 DLC minutes.
Lordship, that is the thing, lordship. So lordship, when lordship she was appointed, her service was adjusted lordship in the year 2005. She has been continuing in her service lordship as a Sokidar of the said school, but she didn't receive any salary lordship.
But this is a different issue.
Lordship, different issue. But thereafter, lordship, in 2017, lordship, when the lordship, the concerned headmaster of the school informed this petitioner that since her case has not been considered and she is not getting any salary also, she was lordship asked to request the
Where's your application?
first application lordship. Lordship will find up page 14 is the first application. This is the lordship translated copy. And she also, this in the year 2008 also lordship, he submitted another application, the second application, that is at page 25. Lordship. So in the year 2008, lordship, she again submitted an application to consider her application. In the meantime, lordship, although it was lordship, the DLC was there, it was never communicated to this petitioner. So lordship, she was completely dark of this aspect, lordship. She has been continuing lordship in the state post as a Sokidar of the school.
Where's the DLC minutes?
Lordship. DLC minor lordship, page number 35 lordship. It is type copy. The original starting from lordship page 38. Her name is if lordship coming to the page type copy, then it is page 36.
In the original?
In the original lordship, it will be at page 39. Serial number 2, the dark portion lordship. Serial number 2, Riju Das. Date of application is date of date is 10/10/2003. Date of application 13/10/2003.
Serial number?
Serial number 2, Lordship. It at page 39. Spent force. Remarks column.
Name?
Riju Das. Serial number 2, Lordship.
No. There's no Riju Das here.
Riju Das, Lordship.
There's no Riju Das.
In remarks column, Lordship, it is mentioned as spent force. Then if Lordship, see the other person, other candidates, Lordship.
1 minute. Page 39.
Remember, page 39. The second dark row also.
Second, serial number 2 is Jayanta Burman.
No, Lordship, this is the 3, Lordship. Jayanta Burman is 3. The second dark portion, Lordship, you see in original copy. Sri Riju Das. Perhaps, Lordship, it has not been, Lordship, reflected because of this original paper, Lordship. Lordship, come to paste type copy.
No, in the original.
Original, yes. Original serial number 2 is here, Lordship.
Where's serial number 2?
Lordship, the dark portion, the second dark row.
One serial number 1 is one Raju.
Raju Sodhi, that next is.
Huh?
The next is dark portion, Lordship.
Okay, in the dark portion.
Lordship.
Riju Das.
Lordship.
Spent force.
Yes. But other candidates, Lordship, although they have also submitted their application in 2003 and 4
Received this copy.
in 2022 only, after Lordship filing RTI application. Lordship will come to page 27. Page 27 is the letter, Lordship, issued by Additional Deputy Commissioner Nalbari to District Elementary Education Nalbari. This is type copy, the original is at page 28. The original are not legible, Lordship, that is why I have typed all those papers. Lordship. The ADC has forwarded the application into 6/8/2021.
Then
Lordship may come to page 31. This is the response of the letter of ADC, Lordship, by the District Elementary Education Officer.
yes.
Lordship. So if Lordship, we see the
Yes, second.
My lord. My lord, that 12/9/2008, that is DLC minus my lord. There is a no wrong in the part of that DLC minus. Because my lord, application pending for 2003, my lord. Honorable High Court said, my lord, if my, and as well as guideline says, if my lord petitioner's application is pending, my lord, due to.
When was it placed before the DLC?
My lord, 12/9/2008, my lord. He made application in 2003, my lord. From 2003 to 2008, 5 years, my lord. No vacancy, my lord.
Whose fault?
My lord.
whose fault?
But that has placed, my lord.
When was it placed?
My lord, up to 2008, my lord.
2008. She
2008,
made her application in 2003.
my lord.
Then what can she do?
No, my
What
lord.
can the petitioner do?
Even,
She already made her application.
even
And
my
then
lord,
you're sleeping.
that part is page number 39 is not properly legible, my lord. Even we cannot say that where application was placed, my lord. Whether it is second application or.
Get the original copy of this DLC.
My lord.
My copy is legible, Lordship. My friend can go to this copy, Lordship. It is legible, Lordship.
Even in my copy, it is not legible.
That is why I have typed all those papers, Lordship. It is legible, Lordship.
Let me verify from the DLC.
So
my
may I
lord.
pray one thing, Lordship?
And even
There is
my lord,
special drive
2008,
going
my
on,
lord.
Lordship. The last phase of special drive is going on to appoint all those compassion appointment, Lordship, by the government of Assam. If Lordship may direct the Deputy Commissioner or the DLC authority, Lordship, to reconsider her application, that's enough, Lordship, I think. Because she has been working since 2003 up to 2018, Lordship, honorarily, a widow, Lordship, along with her 5 minor daughter, Lordship. So that much, I think, Lordship will consider.
That
Let
part,
us-
my lord, regarding the honorary appointment, my lord, concerned departments may say. Even
That
my lord, there is a
that
direction, my
that
lord,
has
of
got
say,
nothing to do with the competition appointment.
my lord.
Yes.
Of course, it was a
Yes.
competition by appointment by
It has been
that
also
part,
regular,
my
on
lord,
But
regular
the issue
basis.
is, she made her application immediately after the date of.
Yes.
My lord. Even my lord.
Then that application was lying with you.
Yes. And if
With
Lord-
the- with the- with the
But my lord, on the basis of the submission made by the petitioner, we cannot say, my lord. Because my lord, this is whether it is, my lord, placed on one time or second time, we cannot say, my lord, without any verification.
Lordship, may I compare one thing, Lordship? If Lordship come to the
Even
type copy of
we
my
can say,
petition,
my lord, after proper verification from the concerned department, my lord, whether it is the concerned department has placed before the DLC or not, or whether it is pending before the concerned department, we cannot say, my lord. Let my lord verify the all aspect, my lord.
Lordship,
And even, my lord, this rejection of the minorities, my lord, proper, if my lord vacancy is not
How it is
available in
proper,
2008, my lord.
Lordship,
Even we cannot accommodate them, my lord. It is on compulsory.
No, you can't do that. You can't do that.
and other applicant, Lordship,
When she makes her application on time,
yes.
you are supposed to place her case before the DLC on time.
My lord. Therefore, my lord, I am saying that this
The
petitioner.
concerned
claimed that is
department,
2008,
concerned
my lord.
department
My lord.
was sleeping over the application made by the petitioner. You can't put the fault on the petitioner saying that it has spent its faults.
My lord, even my lord, scheme said, my lord, within 2 years, my lord.
Within 2
my
years,
lord,
you should have placed
it is
it,
the motto of the
you
scheme,
should
my
have placed it within 2 years. Have you placed it?
No, my lord, I am saying that if concerned department will place before the DLC, then DLC can take responsibility, my lord.
Does the
Now we
same,
cannot say, my lord, it is delay on the part of the deputy commissioner or delay on the part of the concerned department. Let us verify, my lord.
yes, you take instructions and
My
come back.
My lord.
And other application, Lordship, those who will file Lordship in the year 2004, that are considered.
I'll give you a short time.
Yes, short, Lordship.
But Mr.
J. Kolita, Lordship.
J. Kalita, let's counsel for the petition. Stop. Para. The husband of the petitioner while serving as a regular employee of the government of Assam under the education department. No, sir, don't say that. Cancel. The husband of the petitioner while serving as Chokida at Palikuchi MV School, Nalbari, died in harness on
10/10/2020,
10/10/2003. 2003. Stop. Thereafter, the petitioner met her application for appointment on compulsory grounds on 13/10/2003. The case of the petitioner was considered by the concerned DLC in its meeting held on 12/9/2008. However, her case was rejected on the ground that it has spent its. You are to take instructions or Mr. Fukan is to take instructions?
Both will take it.
I have to take mine, sir.
Mr. A. Fukan, an standing counsel,
Elementary education.
elementary education, and Mr. P. Saika, learned government advocate shall both take instructions as to whether the concerned authorities had placed the application of the petitioner before the concerned DLC on time. Stop. Please, no matter after. 1 week.
10 days.
10 days.
Fixing a date, Lordship, otherwise it will not come, Lordship.
Today is what? 23rd.
Today is Lordship 23.
8.
8, Lordship.
September.
Oblige.
13.
Lordship, Mr. may pass over for time being, Lordship.
Or
D. Borgman will submit, Lordship. Says legs obliged.
14.
May I please your lordship? Lordship, the petitioner is serving as the headmaster of Pahartari Habibi ME Madrasa. Lordship, there is a minority scholarship scheme for the students of the class 9 and 10, Lordship. During the year 2019 and 2020, the scheme was provided to the students for scholarships. They obtained scholarships, Lordship. And during that period, Lordship, there was a allegation of misappropriation of fund by the headmaster and the students, as well as the concerned CSC centers, Lordship. Thereafter, Lordship, the pertaining to that allegation, Lordship, the petitioner was placed under suspension, Lordship. The suspension order is at page 43, Lordship.
yes,
May I read, Lordship? The first paragraph, whereas as per record, some students in Pahartari Habibia ME Madrasa Somaria Educational Block had availed pre-matric scholarship, minority scholarship in the year 2019, showing themselves as the borderers of school hostel, though the school is not having hostel. Whereas as a head of the institution, Abdul Quddus, headmaster Pahartari Habibia ME Madrasa, had verified such applications and allowed the students to draw the scholarship in enhanced amount with such false information. Lordship, there were 124 applicants, out of which 97 students' applications were approved by the headmaster. And out of those 97, Lordship, 35 students have received an enhanced amount of scholarship by showing themselves as borderers of hostel, although the madrasa is not having hostel, Lordship. Thereafter, Lordship, the petitioner had was served a show cause notice, page 46, Lordship.
yeah,
Thereafter, Lordship, he had served a reply to the show cause notice. The page 47 is the show cause reply, Lordship. Page 47, he had clarified the allegations against him. And also, Lordship, page 54, Lordship. Based on his suspension, the BEO have Block Elementary Education Officer had clarified certain facts regarding his suspension to the director, Lordship. Page 54 is the type copy, Lordship. May I read, Lordship?
Yes.
Lordship, I will take you to the last paragraph, Lordship. Abdul Quddus is the headmaster of Pahartari Habibia ME Madrasa. He was placed under suspension by order dated 4/11/2020, issued by the District Elementary Education Officer. At that point of time, I was not working as the Block Elementary Education Officer in this office. Next page, Lordship. There is no record found in our office regarding the complainant who made allegation against Abdul Quddus. The guardians of the students of the madrasa had submitted the applications of the minority scholarship before the headmaster for verification after online submission by themselves in computer center. There was no computer on the office of the headmaster. The headmaster did not have sufficient knowledge of computer. Hence, he sent all the documents before the concerned authority for approval after verification. But he could not ascertain the hosteler and non-hosteler students because the madrasa did not have hostel facilities. The 35 students of the madrasa got their minority scholarship as hosteler without knowledge of the headmaster. The headmaster did not have any role in crediting the amount in the respective account of the students. The
Yes,
said information has been received. Lordship, that is on the basis of the report and on the basis of the show cause reply, Lordship, the petitioner was again reinstated in service. Page 59 is the reinstatement order, Lordship.
yes,
Pending drawal of departmental proceeding and outcome of CID PS case number so-and-so, Abdul Quddus, headmaster Pahartari Habibia MEM, is hereby reinstated in his original place of posting for utilization of his service, except the works related to financial matters till the completion of the CID investigation. The senior most assistant teacher will continue the work related to financial matters in the school until further order. Lordship, although he was reinstated, Lordship, the financial matters of the school were entrusted upon the senior most assistant teacher. He is curtailed from the financial matters, Lordship. Lordship, thereafter, Lordship, he approached the authorities, but they said that due to the pendency of the PS case number, Lordship, I have annexed the FIR. The name of the petitioner is neither in the FIR nor in the charge sheet, Lordship, regarding the anomalies in the scholarship. Now, Lordship, during the suspension period, certain benefits were curtailed from him, Lordship. I've stated in the petition as well as prayer, and the financial powers are also curtailed from him, Lordship. And the departmental proceeding that has not been continued because they are satisfied with the so-called reply, Lordship, along with the report of the BO. But certain things are curtailed from his salary, Lordship. That is why he is before your Lordship.
Yes, but
Lordship, as far as the department stand is concerned, Lordship, today, Lordship, notice me go. We will, in the meantime, get my instructions. Lordship. I'll file my affidavit.
MS.
K. Talukdar, Lordship.
Talukdar and counsel for petition. Issue notice. Infocal notes. Standing counsel, elementary education.
On the response.
Appears on behalf of all the respondents. Notice and respondents are complete, however, extra copies of the petition is released in the standing counsel. Responses are to final contract. Listed.
I have also made a prayer regarding the interim, Lordship.
Interim, nothing.
That applies to.
15.
Pass over for the time being, Lordship.
I think
that there are similar matters which has been moved before this court. And that order has been passed. 2 orders has been passed, kindly see last order. And already the matter is being taken, it's been heard and it's a CAV. 178 kindly be seen, my lord. These are similarly situated, there the advertisement was issued. And there is a prayer where some protection was given because the extension is going to over. So they are continuing in the service. So I think similar order and can be tagged with those cases, my lord.
But those cases are reserved.
Yes, that's why, my lord, this also, this is pending, my lord. This case is pending. This case is pending.
This particular case.
Yes, this is pending.
WBC.
WPC 864 of 2023. That is page 172.
This is pending.
This is pending.
Heard Mr. Didas, Mr. Nikon. Assisted by Mr. Eskenath and the counsel for petition. Issue notice. Mr. The standing counsel, higher education. Appears on behalf of all the respondents. 1 minute. Including response 6.
Yes, madam. Yes, ma'am.
Recruitment.
Yes, ma'am.
Assam Engineering Service Recruitment Board.
Yes, ma'am.
Okay. On behalf of all those. Stop it. Respondents are allowed to apply. List the matter along with WBC number 864/2023. After 4 weeks.
Yes.
Interim is required
Yes, madam.
in the till the next interview. The service of the petitioners. Petitioner or petitioners?
Petitioners.
Petitioners shall not be disturbed
Or a similar order may be passed.
without taking the leave of.
Yes,
Without-
we are taking leave of it. Yes. I'm deeply of it.
51 of supplementary list. Well done.
Before my senior starts, my lord, in this case, I am for the private response number 6, my lord.
Have you filed a caveat?
Yes, my lord, it was, but not in number, my lord, yes. We have filed it subsequently, my lord, before filing the petition, my lord. That's why it is not in the report, my lord.
At that time, it was not there, my lord, what they submit, my lord. I'll give the copy, but then, my lord, some interim protection would be necessary,
Day
my
after
lord.
tomorrow, my lord.
Yes, my lord, till then, at least, my lord, the order may be, my lord, state or any consequential order should be.
My lord, day after tomorrow, my lord. My lord,
Let us see the impugned order.
Yes.
if my lord, remember, my lord, this
This litigation is, my lord, although filed by the petitioner earlier, my lord. This honorable court had directed the, my lord, both the petitioner and private respondent to appear before the respondent authority, my lord, the government, for the hearing, my lord. After hearing, my lord, the speaking order, this speaking order has been passed, my lord. This 18-8, this order has been passed, my lord, which is done as per this honorable court, my lord. And the last occasion also, my lord, status quo order was there. Only issue this, my lord, only the BA degree, which is said to be invalid of the private respondent number 6. My lord, 2 times, my lord, respondent has verified and passed the order in favor of me, my lord. That's my BA degree is invalid, my lord, my lord. Well, day after tomorrow, my lord, my lord.
My lord, the order that has been passed, it is the same order which has been set aside by your lordship. Same order. In fact, my lord, the case was, my lord, with regard to the, my lord, filling up the selection and appointment of the post of principal. My lord, he was the respondent number 6, my lord, case was forwarded at serial number 1 and mine was, my lord, forwarded at serial number 2. He was granted 20 marks, I was granted 18 marks. But this was not as per the, my lord, guidelines. So I submitted the representation before the authority. They did not consider. So I approached this court. This court directed that you decide the matter of appointment, taking into into consideration the grievance of the petition. Now, my lord, the authority what have done, without going into all these things, my lord, they have straightway, my lord, appointed me to the post. That was challenged by them before this honorable court. And this court, my lord, during the proceeding, the government has submitted that, my lord, he is not eligible because his BA degree is not from a college which is recognized under the law. But then this fact was not, my lord, placed before, my lord, by any hearing, or no opportunity was given to him. So therefore, this court has, my lord, directed them to reconsider the matter and, my lord, make an inquiry with the college concerned and the NCT whether his BA degree is valid or not. And if, my lord, that comes in favor of the, my lord, respondent number 6, in that case, a hearing opportunity will be given to me as well as him and pass a, my lord, consequential order. Now, my lord, what they have made an inquiry and they found that the BA degree is valid. And without giving any opportunity of hearing to me, my lord, on the basis of that his, my lord, the BA degree is valid, my appointment was cancelled. His, my lord, he has been appointed. That has been challenged before this court by me, and your lordship was, my lord, occasion to deal with the matter and dispose of the writ petition, directing them to give an opportunity of hearing to both the parties and take into the consideration of the grievance and decide the matter. Now, my lord, they did not, my lord, the objection that have been raised by me, nothing has been considered, only on the basis of what was recited in the earlier order that his BA degree is valid. So, my lord, my lord, observed that the respondent number 6 should be appointed as a, my lord, principal. So that order I have challenged.
Who is the order passed for this court?
Yes, my lord, that's page 45, 46, my lord. Lordship may come to, my lord,
regarding, my lord, take up the hearing, my lord, which is already done, my lord.
my lord, page 48, my lord. Being aggrieved, the respondent number 6 filed WPC number so and so before this court challenging the appointment of the, at page 48. Appointment of the petitioner as principal of the said college by order dated 7/8/2001. After hearing the parties, WPC number was disposed of by an order dated 11/8/2021 and the operative portion read as under. The appropriate authority shall specifically call for the records from the Borpeta BT College as well as from the NCT to arrive at a factual satisfaction as to on which that college made an application for recognition before the NCT. Depending upon the materials that may be available, appropriate order may be passed. If the order to be passed by the approving authority in the government is in favor of the petitioner for the purpose of other consequential action that would be required to be taken, both the writ petitioner and the respondent number 6 would be given an opportunity of hearing to put across their respective cases till the approving authority takes its decision. Thereafter, the consequential action are taken. The respondent number 6, the principal of Bamundongra Higher Secondary School, shall continue to remain as such. His further continuation would depend on the logical outcome of the
process as indicated above. The approving authority under Rule 13(5) to take its decision within a period of 3 months from the date of receipt of the certified copy of the order, and thereafter consequential action to bring the process to its logical and may follow. The writ petition stands closed and disposed of. Thereafter, the Secretary to the Government of Assam, Department of School Education issued an order dated 9/3/2023 by which it was held that the respondent number 6 may be notified as principal of a higher secondary school of the Barpeta district, as the B.Ed degree of the respondent number 6 was authenticated by NCT. The operative portion read as under. Being agreed with that without hearing to the petitioner and not taking any report from the concerned authority on the authenticity of the document related to his B.Ed degree, Department of School Education rejected the candidature of the petitioner for the said post on the ground that the petitioner's B.Ed degree is not valid, and DSC had issued an order to appoint Majid Ali as principal of the above mentioned school. Petitioner filed instant case. The Honorable High Court had disposed of the case by order dated 11/8/2021 with a direction that the approving authority in the government will verify the records document relating to B.Ed degree of the petitioner and will conduct a hearing to put their respective cases and will dispose of the matter. In compliance of the High Court order, a hearing was conducted on 20/10/2021 at 2 p.m. in the office chamber of Special Commissioner Secondary Education Department. Hearing was attended by the petitioner NC Majid Ali. In the said hearing, the petitioner had submitted a photocopy of NCT letter regarding NCT recognition up to the end of academic session 1997-98. The documents were sent to NCT for authentication via order dated 1/11/21 and followed by 3 numbers of reminder. In the meantime, the petitioner filed a contempt petition bearing content case number 23/22, alleging that department has not complied with the court's order dated 11/8/2021 passed in WPC number 355/821. NCT has authenticated the document pertaining to B.Ed degree obtained by Sri Sajal Kumar Das, it is respondent number 6, by order number so-and-so, dated 21/2023. Order, after careful consideration of the above, and the approval of competent authority obtained accordingly, it is decided that Sajal Kumar Das may be notified as principal, Bangdongura Higher Secondary School, Nagaon. Consequently, in charge of Director Secondary order passed order dated 29/4/2023, reverting back the petitioner to its original post of postgraduate teacher of Rehabari Higher Secondary School, Barpeta district, and appointed the respondent number 6 as principal on regular basis of Bamundongra Higher Secondary School of Barpeta district. Being agreed with the order dated 29/4/2023, passed by the in-charge Director of Secondary Education, Assam, the petitioner is before this court on the ground that while Secretary to the Government of Assam, Department of School Education considered the matter, the judgment was misconstrued and not in conformity with the direction contained in the order dated 11/8/2021, passed in WPC number so-and-so. I have considered the order dated 9th March 2023. A perusal of the same would indicate that a hearing was conducted by the concerned authority before coming to a conclusion with regard to the status of B.Ed degree of the present respondent number 6. What was directed by the order dated 11/8/2021 was that the concerned authorities shall call for the records from the Barpeta B.Ed BT College as well as from NCT to arrive at a factual satisfaction as to on which date the college made its application for recognition before the NCT. The order further directed that it was only when the concerned authority is to issue an order in favor of the petitioner therein respondent number 6 in the present writ petition that hearing would be held with regard to the writ petitioner and present respondent. This has not been done. Accordingly, the matter is remanded back to the Secretary School Education Department to rehear the petitioner as well as the respondent number 6 on the order that is to be passed by the concerned authority and thereafter pass appropriate order in accordance with law within a period of 2 months from the date of receipt of the copy of this order of this court. Consequently, the order dated 9/3/2023 issued by the Secretary to the Government of Assam, Department of School Education is set aside and quashed. Now, my lord, the order has been passed at page 62. Same recitation, the objection that I had submitted has not at all been considered. You'll also will find at page 62 is the impugn order. The entire the facts have been sequence of events that I have narrated, and finally they come at page 63. The last paragraph. NCT has authenticated the document pertaining to B.Ed degree obtained in Sri Sajal Kumar Das via letter number so and so
legal sanction dated 21/23. A hearing held on 11/8/23. Compliance of High Court order dated 19/6/23 passed in WPC number 4/2/23 filed by Majid Ali after verification of all relating to records to the B.Ed degree of petitioner and careful consideration of the above and approval of the competent authority obtained accordingly. It is decided that Sri Sajal Kumar Das may be modified as principal Bamun Dongra Higher Secondary School, Borpeta. My grievance, my representation, the consideration is not at all done. What is my grievance, your lordship will find. This has been also, my lord, called, my lord, at one point of time at page 32. Page 32, my lord. In view of the fact the court has referred to the letter dated 28/29 enclosed and further Sri Majid Ali in his representation dated 13/1/2020 has alleged that Sri Sajal Kumar Das, MPNL at serial number 1, is not eligible for any marks under the National Award, State Award Leadership Skill. He has also alleged that Sri Sajal Kumar Das is not eligible to get any marks awarded under the head principal in charge, as Sajal Kumar Das joined in charge principal on 13/6/2019, and the interview was conducted on 15/6/2019, and he did not complete 1 year as in charge. Well, this was basically my grievance, and the only date of hearing also I have submitted a written argument, which is also part of the record. There I have clearly spelled out what is my objection. The lordship has found this particular order has been passed. What was done in the earlier order, that order has been set aside. Same, repeatedly they have done the same mistake here and passed the order only on the consideration that his B.Ed degree is valid. He may be granted sometime, but this order may be invested till then. Regarding the grievance part, my lord, when the selection committee has taken the decision, my lord, that my B.Ed degree is invalid, my lord, the writ petitioner has been given the charge, my lord, principal. From the said selection process, my lord, the writ petitioner has accepted his, my lord, the post of the principal, and that selection process has never been challenged in the earlier writ petition, my lord. And this is the third round of litigation filed by the writ petitioner against the, my lord, this private against me, my lord. And the order passed by this honorable court, but that is already attained finality, my lord. That was not reviewed, my lord. And the last occasion also, my lord, this honorable court has passed the status quo order, my lord. And the response number, my lord, the amendment already, my lord, 2 times has considered my lord, that my prayer, my lord, that I am the my B.Ed degree is valid, my lord. And on that you file your cabinet. Yes, my lord, is to be, my lord. Day after tomorrow, my lord, is supplementary. Have you filed it? Yes, my lord. Have you filed your cabinet? Yes, my lord. Yesterday, my lord, filed. There is technical error, my due to they have not numbered yet, my lord. That's why it's not in record, my lord. You will take up tomorrow. Tomorrow, my lord. Till this matter, my lord. Up to tomorrow. Tomorrow, at least, my lord, no consequential order may be passed, my lord. The last writ petition also, my lord, please. The same thing, lordship. Yes, my lord. Go ahead, please. Please go ahead. My lord, in the last occasion also, my lord, the petition, this private also is suffering, my lord. Already his B.Ed degree is said to be valid, my lord, by the NCT, my lord. Only this part, and the last writ petition filed by the, my lord, writ petitioner, my lord. On that, the grievances of the hearing was not conducted, my lord. This honorable court always remanded back the matter to conduct the hearing, my lord, and the hearing was already concluded. And thereafter, my lord, this impugned speaking order has been passed, my lord. Therefore, my lord, take up the day after tomorrow, my lord. Or my tomorrow supplementary list, my lord. Yes, Chisti. My only tomorrow or day after tomorrow, my lord. As per
that was the direction, last direction that second should hear the both the parties. That was hard, and this order was issued.
As per direction of this.
Don't pass any consequential order.
Yes.
I'll inform.
Then I'll record it.
And only that have to communicate it. May record it.
My lord,
I am holding the charge of the post, my lord. Consequential order has not yet passed, my lord. Let it be tomorrow or day after, my lord. At least, my lord, the consequential order may not be passed, my lord.
Then tomorrow,
tomorrow, my lord, tomorrow supplementary list, my lord.
Then no,
Tomorrow, no.
Yes, my lord.
First, his undertaking may kindly be recorded, my lord.
no,
Because
another thing I cannot keep right now.
This, so
Already
your
he
lordship,
has- he has submitted that no consequential order has been issued. So that's why his submission notice.
yes.
Every time, my lord, the petitioner has come with the new writ, my lord. Same with the same grievance, my lord.
P.J. Cycle, then senior counsel, assisted by Mr.
M. Kolika.
M. Kalika, let the counsel. Mr.
S Hazarika.
S. Hazarika in council. For the respondent number
Number 6, my lord.
6 submits that he has filed the caveat on
Well, yesterday, my lord.
yesterday. on 22nd August. The court is list this matter along with the caveat application. On. Tomorrow, 24th.
Tomorrow, my lord.
Till then, no consequential order be passed. My lord.
I'm
If
sorry,
it is,
my lord.
if it is passed, my lord, but my nature and character of the my lord, repetition change because
My
I have to challenge the my lord order of removing me from the post. my lord.
Only, my lord.
I am holding the post.
My lord, only speaking order has been passed, my lord. No final decision has been
Yes,
taken.
my lord.
That's why I'm saying,
Lord.
no final decision.
Yes.
will be passed. Till the next section. No final orders shall be passed. Pursuant to the
Order dated 18th August 23.
order dated 18th August 23 issued by the Secretary to the Government of Assam, Department of School Education.
Obliged. But till tomorrow, my lord, may be recorded, my lord. Please, my lord.
That's why I'm till the
Tomorrow, my lord. Obliged.
5 minutes. 5 minutes.
Item 11.
May I please, my lord? My lord, the petitioner before my lord had aspired for the post of professor. Well, my lord, there should be some instruction from their side before my lord can. Then, my lord, she was short by 7 days, that qualifying period. With this advertisements were not out, my lord. She went to the vice chancellor, submitted an application. Vice chancellor, noticing her exemplary service, my lord, said 7 days condone. Accordingly, advertisement was issued. She submitted her application, was not considered. Then again, my lord, we approached, a committee was constituted. Committee recommended in my favor. Then, my lord, nothing was done. I came up before this honorable court, matter was remanded back. A committee was constituted by the executive council now, the Gautam University Executive Council. That committee also, my lord, recommended in my favor, saying that she should be given from 2002, my lord. She was given in 2004. 2002, she should be given. My lord, still not given. I come up before they reject it. I come up before this honorable court. This honorable court said, nothing doing. That decision is bad. Reconsider by taking into account the report of the committee. Again, my lord, they have rejected. I am before your lordship, my lord. This matter, my lord, on the first day, if it remanded back, it will not be of any use. My lord, let my friend have his instructions in the matter. My lord will fix a date. On that day, my lord will consider, because she is also on the verge of retirement now, my lord. If lordship can have the matter, my lord, say after 10 days. In the meantime, let them have their instructions, whatever they want, my lord, so that at one go, this can be done, my lord.
That you can hire in the senior council, assistant prime minister. D. Dekar, and council. Mr.
A. Ahmed.
A.
For all,
Ahmed, then standing council.
Gautam University, my lord.
Guwahati University shall receive instruction. List the matter on, give a date.
2 weeks. Fine.
After 2 weeks.
Lordship. Argument.
Today,
My lord, let it be on the 7th or 8th, my lord, whenever it's convenient to your lordship. 11th. Much obliged, lordship.
September.
My lord, he'll place his instructions on that day.
17. They were getting application.
My lord, actually, we want final disposal of this matter, my lord. This is regarding selection of assistant professor. I secured, my lord, hash mark. I top in the interview, my lord. But they are going to appoint, my lord, person who has, my lord, bottom of the list, my lord. And only count that he's from the BTAT.
No, PhD.
He's got PhD, my lord. So that's why, my lord, your lordship kindly see, my lord, page 29, my lord. Earlier also, your lordship has, my lord.
Lordship is taking up the entire matter for final disposal. Because I have a stay vacating application.
So I want, my lord.
Have you filed your affidavit in the
No, but authority has not been filed. Beneficiary filed. Authority, my lord. That is very important, my lord.
Everything will boil down to one small point, my lord, that I have been selected because I possess PhD and also because I avail from the BTR region. Now, it is a policy decision that preference should be given to candidates from BTR region. Now, he has not challenged that policy decision. His entire case depended on the fact that I have been selected because I had a PhD degree.
Actually, what is the meaning of preference?
Yes, that your lordship will decide, my lord. Now, the BTC is a, my lord, they are one of the formal parties.
Who appears for BTC?
Till date, none
None,
my
my
lord,
lord.
no one has even cared to file an affidavit.
So that is the.
No, last occasion, B. Chowdhury was appearing for BTC.
Yes, my lord, that is ordered at 24/2023. So we want final disposal, my lord. Anyway, my lord, your lordship kindly.
Even the college is suffering, my lord. I might be the recommended candidate, my lord.
My lord.
But
He's
the college
correct,
is
my lord.
suffering.
College is suffering.
Yeah, who appears? Call the BTC council.
BTC din na BTC affidavit din na.
Otherwise, you filed your affidavit in the main.
My pleadings are complete. The governing body has also filed their affidavit.
I mean, okay.
Response number 6.
Yes. They have filed their affidavit. Even I have filed.
Response 5.
আজি এনেকে মুখখন খোলা ন আজি নেপালী নাই কোন এপি হয় বিক্ৰম চৌধুৰী মানে মই আসাম গভৰ্ণমেণ্টও দিবলৈ কৈছিলো আসাম গভৰ্ণমেণ্টৰ নাই
We can take up after some time. You send your junior to
My
call the
I have
PTC.
sent my junior to he asked me no problem.
Implement of party.
In this case, my lord, we have prepared our affidavit, my lord, we are going to file today, my
Which case?
18, my lord.
You wait till counsel.
In IA, my lord. In IA 3175.
You're filing your objection.
Lordship.
None appears for the applicants. Mr. R. Ali, legal counsel for the writ petitioner, public party. Submits that he will be filing his objections within the course today.
Lord.
Within the course of the day. This is the matter after 1 week.
Obliged.
19.
Implement method, new incumbent as a respondent 6, 7, 8, and 9 minute. Page 8 minute, para 6 minute.
What are your respondents?
Respondent 6, 7, 8, and 9. Page 8, para 6.
1 minute. Page.
Page 8 minute,
Para.
para 6.
Yes. Okay. But Mr.
B. Kumar.
E. Kumar.
Yes.
Legal counsel for that. By this application. The applicant is paying for inflictment of page 8, para 6, 8A. As party respondents. 6, 7, 8, and 9. In contempt case number 402 of 2020. On the ground that the aforesaid persons has taken over charge of the respective departments due to the transfer has taken over charge as
One is retired, my lord, and other is transferred.
the early incumbents have retired, oblique, been transferred, stopped. But after considering the portion in the present application, prayer for impeachment is allowed. Stop. I is dismissed. In the contempt, in view of the order passed within I number 7, let you put the full name again. Be impleted as party respondents 6, 7, 8, and 9. Stop. Petitioner is direct to file an amended post within
1 week.
within 1 week. List after 1 week.
Public.
20, admission.
My lord, on last occasion, instruction was called for, but the instruction not received, my lord. Under my lord, 2014 letter, my lord.
Huh?
That may not be there. The letter of 15/12/2014. But
Yes. My lord, they are
that
supposed to get,
instruction was not received, my lord.
you're Mr.
Yes,
G. Goswami, not J. Goswami, and Mr. A. Double dot. No, J. Biku, the standing council,
Elementary,
elementary education is allowed. Another
1 week.
1 week time to receive instructions.
Public.
One and 22.
Please, your lordship. Lordship, in this matter, the pleadings have been completed and the affidavits have already been exchanged. Your lordship may kindly fix the matter for final disposal on the 2nd week of September.
Your good name?
V. Shoy on behalf of Mr. J. Chutin.
On the curse made on behalf of Mr. J. Chudya, then counsel the petition. List the matter. After 2 weeks.
Hello, I am appealing the 2 and 4.
Mr.
Economical.
A chronicle and council affairs correspondent.
2 and 4. 2 and 4, madam. 2 and 4.
All right, lordship.
23.
May I please, your lordship? Your lordship, in this case, the petitioner has been serving in the Barbara T. State LP school since 2009, your lordship. In 2011, the labor union raised some objection against his appointment and he was debarred from signing the register. So he approached the Assistant Labor Commissioner Dibrugarh. So after going through the matter, the Assistant Labor Commissioner Dibrugarh directed the management to reinstate him in the service. So in 2018, he was appointed. And that annexure is, your lordship, annexure 1.
Page.
Your lordship, page 13. It is the certificate. Page 14, your lordship, is the appointment letter. With a salary of 12,636, your lordship. And thereafter, again, the management of the tea estate issued an impound order by dint of which he was his service was kept in abeyance on the basis that some objections has come against his appointment and there can be some law and order situation without giving him any opportunity of being heard and without giving him any notice, his service was kept in abeyance, your lordship. And thereafter, and that order is, your lordship, that is annexure 3, your lordship. That is page 15, your lordship. And then again, he approached the Assistant Labor Commissioner, who again directed the TA state to take the necessary action in this regard, but they have not done anything. So ultimately, he is compelled to approach this honorable court, your lordship. Your lordship, the thing is that neither he has been given any notice, nor he has been given any opportunity of.
You are back to appointment, isn't it?
Yes, your lordship.
You are back to appointment.
No,
When
no, lordship.
you
If,
are appointed without any interview,
your lordship, but they have not.
without any written test, without going through the recruitment process.
No, your lordship, they have not, because if it would have been found, then the Assistant Labor Commissioner has gone through the entire matter, your lordship. And thereafter only that order for his appointment was issued, your lordship. And they did not challenge it. I was appointed according to procedures, your lordship.
Yes, then what happened?
Then again, they said that there are some objections against your appointment by the labor union. So your service is kept in abeyance. And that too without giving me any opportunity of being heard, your lordship, without notice. Suddenly I have been out from the service. And your lordship, if there could have been some law and order situation, they could file an FIR also, your lordship. Only on the basis that there can be some law and order situation, how my service can be curtailed, your lordship.
Yes, respondents, file your
I am for the
affidavit.
private respondent 6 and 8, lordship.
Yes.
The school and
Yes.
headmaster. Lordship, earlier also the suspension was withdrawn, but the agitation by the labor union.
Have you filed your affidavit?
They have neither filed any complaint, your lordship. No documents have been adduced by them.
Have you filed your affidavit?
Affidavit, lordship, not in the record.
Have you
It is
filed?
Not filed. I have not filed.
Obviously, when you don't file, then how will it be on records?
And then your lordship, on last occasion, they said they would not file an affidavit and the matter may come for hearing.
Is it correct?
Lordship,
1 minute.
there is a gap. And my senior would have been there on the last occasion.
Yes, this one number 8.
Yes, lordship.
Your age?
6 and 8.
6 and 8.
That may be, your lordship, on the order that they would not file any affidavit, so it is coming for.
Yes, then
Lordship, the sanctity of running of the school is under stake. If we reinstate the petitioner, again, there will be
No, your lordship,
functioning of the.
yes, you have said that you are not filing your affidavit. Obviously, that means that you are agreeing to what the petition is relying on the writ petition,
Lordship, hearing,
isn't it?
we don't have any personal grudges
That's
with
why.
the petitioner, but the sanctity of school would not function properly if agitation will be there from the union.
but they
Yes,
have not adduced any documents of your lordship of complaint, nothing.
Yes.
There is no other grievance with the petitioner. The agitation by the union, we don't have any document and in that regard, but as soon as is reinstated, the same agitation.
Yeah, what do you say? Begu?
My lord, may call for present status of the petition.
What status report?
Discuss report of the
What status report?
present situation, my lord, because now
How
maybe
can-
maybe sense, my lord.
How can you give the situation?
And your lordship, what happened in
The-
between?
This school is functioning under whom?
It's a pencil school. your
Answer
It is a venture school.
And your lordship, what happened in between? The government of Assam has issued some notification for provincialization of the services of the venture school teachers. and the district scrutiny committees were constituted and they were directed to scrutinize the eligible candidates, and if found to be eligible, then to forward it to the state level committee. And thereafter they can be appointed as provisionalized teachers, and they are expedited in personnel to the persons to be appointed, which is not going to affect the present cadre of service post of the government, your lordship. So because as I was out of the service, so that benefit I also could not avail, your lordship. I have been also debarred from them. Those are page number 17, your lordship. Are the government notifications?
Where's the order of the Labor Commissioner?
Your lordship, after the order, I have been appointed. I have.
Where's the order?
That order is not annexed here, but your lordship to 19, that
You
annexure 4.
produce, do you have a copy of the order?
I'm not now, your lordship, but I have a copy of annexure 4, your lordship. That is again, when again my service has
That
been.
copy of annexure 4 is also available here. I'm asking you the order of the Labor Commissioner.
The first order, your lordship.
Huh.
That is not with me. Only after that I have been appointed again, your lordship. And that part has never been denied by them also, your
That's
lordship.
fine. Where's the order? Let us see the order.
I have only 2019 year order, your lordship. The original order. That order is not with me, your lordship.
Produce a copy.
Your lordship?
Produce a copy.
Okay, your lordship, I will.
MS,
Yes, sir, ma'am.
then it's counsel for the petitioner. Shall produce a copy of the order passed by the Labor Commission. List after
After 1 week, your lordship.
1 week.
Obliged.
The prayer for adjournment, isn't it?
Your lordship, with the consent of the other party, I beg to adjourn this matter.
You're for it? You're appealing for?
Mr. UK Nair.
You can petitioner.
Yeah, petition.
Your good name
And Newman. And Newman.
on request made on behalf of Mr. UK Nair, legal counsel, legal senior counsel for the petitioner. List the matter after
2 weeks, your lordship.
2 weeks. Okay.
26, 27, and production list 1.
Maybe lordship. My lord, the 26 and 27, my lord. In 26, I am the petitioner, and 27, I am the respondent number 8, my lord. And in the case, my lord, the petitioner and as well the respondent number, sir. They are servicing the semi-school and Bhansar school, my lord.
What is this IA about?
My lord, I filed for the stay vacating, my lord. Their my file, my lord, issue order is 2020, my lord.
You are appealing for?
My lord, I am the petition number 26, my lord. WBC number 4686. And respond number, my lord, 18. And respond number 8.
For the
For the private respondent in item number 26, your lord,
and the petitioner.
in item number 27.
20
Sorry, yes, 27.
27.
IA for stay vacating, lordship, I have not received any copy.
Then you furnish a copy.
Lord, then I want to I searched the clerk search, but he was not received any phone call, my lord. So we're not to sub the copy, my lord. We're ready to sub.
Whatever this petition.
Yes, my lord, I will sub, but I want to disposal today itself, my lord. So
How would it be possible, your lord?
I only for my lord interim
What are that part, my lord? If your lordship heard the matter as a
Are
whole,
you ready?
No, Lord, I have not a copy. How can?
I am not that part, my lord.
IA, are you pressing your IA or not?
I will cap, my lord. I will ready to hire my whole matter, my lord, today. If they are ready, my lord.
So you're not pressing your IA.
If they are not ready today, my lord, then it is pending, my lord.
It's up to you.
Lordship, let them serve the copy today and after a week, the matter may be fixed and the final disposal may be.
She has a right to file an objection.
Then,
to
my lord, next week, my lord.
that will see.
Copy direction may be given to serve. the-
I immediately serve. The copy is available with us, my lord, but they are not.
In the IA.
Yes, my lord. Copy my already served, my lord, in due course of order, my lord. I already served.
Third, Mr.
A. Salim, my lord.
A.
A. Salim, my lord.
A. Salim, London Council for the stop. By this application, the applicant is praying for vacation oblique modification of the alteration of the order that 9/6/2022. Passed in W 62345/2022. MSK Jain, London Council, appears on behalf of the opposite party number 1 oblique petitioner and prays for how much time you require?
2 weeks time.
My lord, 2000 matter, my lord.
This is a application under 226.
Yes, my lord. I
One
copy already served, my lord. Of next week, my lord.
Yes, now I received the copy.
Yes, next week.
Weeks time to file objections, praise the Lord, list after 1 week.
Deeply obliged.
Lord, kindly date.
Will come up.
Sure, I'm sorry, I was not present when the matter was. After 10 years of service, the petitioner has been questioned regarding her qualification for.
Kindly pass over for the timing, B Kaushik will appear in this meeting, my lord. 13. Yeah, he was. Yeah.
When the matter is called up, London Council for petition is not present. Now when she is present again, you are seeking time.
No, my lord, B Kaushik is on leg, my lord. So he was there. So sometime.
If I have one more item 15, then I can proceed with that item. In the meantime, if Mr. Kaushik comes.
Same method.
Later he appeared. It seems that same council will. appear.
Learned counsel for the BPC is there.
Yes. What was this about?
Selection of assistant professor. The assistant professor report. But in this selection committee.
1 minute, 1 minute. Item 17.
Kindly see lordship page number 31.
Who is Mr. Mahanda?
He's on legs.
He was pressing for disposal of this writ petition.
Lordship.
But then it appears you have not filed your affidavit. Then
Lordship, 10 days time may be given, Lordship. Because today or tomorrow I will be receiving the instruction.
yeah, this is last. I'll give you 2 weeks as last chance.
Yes. Lordship.
And my lord, since Lordship is seeking up for final disposal, it may come up under the admission column.
It's coming up onto the admission.
It is under the
stay vacation,
beginning column.
Huh? Okay. Okay. Heard, Mr.
D. Mohanda.
D. Mandal and the counsel for the petition. Stop. Mr. B. Chowdhury and the standing counsel petition. Press for 2 weeks time to file counter affidavit in the main report. Stop. Praise allowed. List the matter. Press for 2 weeks time as last chance to file counter affidavit. Praise allowed. List the matter after 2 weeks in the admission column.
Lordship, in case of D. Mohanta, Lordship T.J. Mohanta, maybe he was there. Mine. Senior
Not
deputy,
Mr. T.K. Mandal. and
assisted by D.
Assisted by
D. Mohanta.
D. Mandal.
12th or 14th of September.
Any date, paying date.
This is the matter on 14th.
Obliged.
28 admission.
May it please your lordships. Because in this matter, on the last occasion, the education department had sought for time for filing affidavit notes. Which their affidavit would be necessary, but there is some urgency also in our part. It is a matter of 2021 March.
Malad, I need some time, Malad. Actually, we misplaced the file, Malad, last day.
We had given the records to them the last occasion.
And Malad, one more thing, Malad, I think this matter was supposed to be listed after 3 weeks, Malad. We have written the letter as 3 weeks not completed, the inspection is still awaited. Malad.
Because may I pray that the last chance may be given to them, Lords, since our promotion is stuck up because of this, Lords.
It is to be listed after 3 weeks.
3 weeks.
Can a date be fixed, Lords?
It's not yet fixed. I mean, like 3 weeks is yet.
Yes, it has come because I had mentioned earlier before the prior date of listing. So I think because of that, it has come.
You've mentioned this matter?
Prior to the last date of listing, I had mentioned, but in the meantime, it had come. It was fixed on 23rd. Manas has permitted to list the matter on 23rd. So, but before that, it had come on the last occasion on, I think, 9th. So because of that, it has come today.
But Mr.
S. Vishwakarma, Malad.
Council for the petition.
Malad, fixed time may be given, Malad. I have already written letter, Malad. Instruction will come, I will file affidavit. 3 weeks, Malad.
Mr. S. Das, the understanding council higher education department. For 2 weeks time to file complaint.
Can a date be fixed, Malad?
This the matter again. 20 September.
Obliged, Malad.
Actually.
29.
Yeah, please, your lordship, kindly the matter be adjourned till next week. The engaged counsel is not well, is not available today,
To
lordship.
the council,
D does, little does.
okay, on request made on behalf of D. Das, then the council for the petition. List the matter after 2 weeks.
The date can be given, lordship.
Oh, let it come out.
30.
May I please? Lordship, this matter pertains to area salary, my lord. The petitioner is working as a headmaster of Uttar Dhinkao Balika LP School, my lord, in the district of Nagaon. My lord, he was suspended on 9/8/2016. My lord, page 14.
Yes.
Thereafter, my lord, he was reinstated, my lord, page 15, on 3/9/2021. Page 15, my lord.
Yeah.
Thereafter, my lord, this reinstatement order was modified by my lord order at page 16, that his period of suspension has been treated as on duty for all purposes, my lord. But my lord, during this period, my lord, my lord, he only got the subsistence allowance. Now this area salary amount would be, my lord, 5,63,589, which is due, my lord. Page 17, my lord, the DDO, wrote a letter to the district elementary education officer requiring the fund for payment, my lord. Page 17. And the my lord, treasury officer has also issued required, my lord, non-royal certificate, page 19. Thereafter, the DDO has prepared the statement of his arrear salary, page 20. So he is entitled to get rupees 5,63,000, which is due for the period of 1/8/2016 to 28/2/2021. Page 20, my lord. all the particulars have been forwarded by the block elementary education officer to the district elementary education officer. No action has been taken.
Yes,
And the notice was issued on 1/6/2023.
why? The simple matter. He was placed under suspension, he was reinstated back. Then his reinstatement was modified by making it as on duty. So you have to pay his yearly salary. When can you pay? That's the whole thing. Come to the mic.
That's right, my lord. So sometime we will have to file our affidavit.
What affidavit do you want to file?
Otherwise, direction may be given to the
Yes.
respondent authority to pay
Oh,
the area salary.
yes. Who's supposed to pay the yearly salary?
It will be the administrative department only, not
Ah.
because I have a notification that was issued by the finance department, my lord, all area salary, because subsistence allowance 50% of the amount is paid during suspension, my lord. There's a remaining amount that is considered as an area salary only, my lord. That will be paid by the administrative department. For that, my lord.
Director.
Director of elementary.
Director.
The DDO has to basically lodge it, give the
Yes.
direction, my lord.
Are you disputing any facts?
Not yet. My lord, so my lord,
Verify to.
after verify,
Lordship may give a direction to verify, and if the petitioner is entitled to it.
yes, my lord, after verification, my lord, verification is needed.
A time
Direction
bound,
may be given to verify. If he is entitled, then they will pay.
To whom is the direction going to be given?
To the directors,
Director,
yes, my lord,
respond number 2.
yes, my lord, director and DO now, no,
DEO.
yes, my lord. DO. To the DO as well as director.
Heard Mr.
M. Ali.
M. Ali, Learning Council for the Petition. Stop.
Then verification. may be-
Also heard MS N. Foucault, the Understanding Council Elementary Education. Correspondence 1, 2, and 3.
My lord,
And Mr. H. Alian, the Understanding Council Finance Department. Correspondence.
Respondent number 4, Lordship. Treasury.
Respond number 4. 1, 2, 3, 5, and 6.
1, 2, 3, 5, and 6. I am appearing, my lord.
And censor for. This one for Charlie. Stop. The petitioner. While serving as headmaster of Uttar Dingaon Balika Mukta School, was placed under suspension by an order dated 9/8/2016, issued by the Deputy Inspector of Schools, Nagaon. No, so the pending role of departmental proceedings against it. Stop. Drafted by an order dated 3/9/2021, issued by the Deputy Inspector of Schools, Nagaon. The petitioner was reinstated in his original place of posting with immediate effect. Stop. By another order dated 14/12/2021, issued by the Deputy Inspector of Schools. The earlier order by which the petitioner was reinstated, i.e. 3/9/2021, was modified by treating the period of suspension as on duty for all purposes. But consequent to the order dated 14/12/2021, the block elementary education officer Julia, Naugam, wrote to the district elementary education for funds to pay the area salary of the petitioner with effect from 1/8/2016 to 28/2021, amounting to an amount of rupees 5,63,589. Stop. The treasury officer Naugam Treasury also issued the non-renewal certificate in respect of the petitioner amounting to rupees 5,63,58. Stop. The grievance of the petitioner before the suit petition is that his area salary is yet to be paid to the petitioner. Till date. Considering the materials available on the court, this writ petition is dismissed, directing the Director of Elementary Education Department and the District Elementary Education Office, directing Director of Elementary Education Assam, /Respond number 2, and the District Elementary Education Officer Naugam, /Respond number 3, to have a verification with regard to the claim of the area salary of the petitioner amounting to rupees 5,63,589. Thereafter, if the petitioner is found entitled to the said area salary, the same should be paid to him at the earliest stop. Let such exercise be completed within a period of 3 months.
3 months will
From the
be
date of
so
the
long, my lord. 2 months.
copy of the order. They'll have some verification, there's some official process.
Obliged.
31.
May I please, Your Lordship? Your Lordship, this writ petition was filed praying for payment of area salaries, Your Lordship, that is due on the petitioner. If Your Lordship for a moment comes to page 24, Your Lordship. Page 24, Your Lordship, this writ petition, the earlier writ petition, Your Lordship, was preferred in the year 2013. Page 24, Your Lordship, annexure F. Yes, this is a writ petition which was earlier filed by the writ petitioner, Your Lordship. The order, Your Lordship, starts on the next page, page 25. It is submitted by Mr. So-and-so, learned counsel appearing for the petitioner, that during pendency of this writ petition, by notification dated so-and-so issued by the Director of Higher Education, the petitioner has been given the benefit of senior scale of pay with effect from 31/10/1997 and selection grade scale of pay with effect from 31/10/2002. The next page, Your Lordship. However, the petitioner has neither been paid the senior scale of pay with effect from 31/10/1997, nor she has been paid the selection grade scale of pay with that effect from 31/10/2002. The operative part, Your Lordship, the petitioner shall file appropriate representation before the Commissioner and Secretary of the Government of Assam, Higher Education Department, through proper channel on or before 14/8/2015 with regard to her grievance of non-payment. So the issue of her payment of area salaries, Your Lordship, had already been decided. In fact, she had preferred her representations thereafter. 8 years has passed by, Your Lordship. Now the petitioner is aggrieved by the order at page 34. Page 37, Your Lordship. I apologize, Your Lordship. Page 37. Annexure K, which has been issued by the Director of Higher Education. The second paragraph states, Your Lordship, that in this connection, it may be mentioned here that there is a budget provision of rupees so and so under the account, head of account so and so during the financial year 2022 and 2023, which was allotted for area proposal relating to a matter of court case, first salary, drop salary. So the only avenue which was left for the petitioner to avail her area salaries, which was legally entitled, Your Lordship, was to approach this honorable court and thereafter have a certified copy of the order and approach the district authorities. This was in fact, Your Lordship, noted down in the earlier order of this honorable court also, dated 31/3/2023. The issues are settled. It has not been disputed. The matter was last heard in the month of March. There has been no instruction, no affidavit in this regard, Your Lordship, filed by the respondents. I pray that Your Lordship will not dispose the matter. Your Lordship will fix the matter after 2 weeks or a week for them to obtain instructions so that the matter can be complied with, Your Lordship. It's almost 20 years have passed and the area salaries, which has not been disputed by the authorities, have not been paid. Only because the petitioner has not approached the court. That is the stand in the order, Your Lordship.
Yes, that's.
Let the matter maybe fix after 2 weeks, my lord.
Just a small instruction, maybe after a week, Your Lordship. They'll only have to verbally confirm before this honorable court. That is all I need, Your Lordship. With the consent of the council, the matter can be closed, but not today.
That's the standing council hired. This allowed 2 weeks time to receive instruction.
If Your Lordship may be kind enough to fix a date, I'll be grateful, Your Lordship. I'm grateful. I'm grateful, Your Lordship.
32. My lord, in this case, director has filed an affidavit today, my lord. I will file reply. Let it come next week, my lord. Short affidavit.
Director.
Yes, my lord. Respondent
Director.
of higher education.
Respond number.
Respondent number 2.
Mr. N. Sharma.
Secondary. Yes. Secondary.
Counsel for the petitioner. Place for 1 week time.
Yes.
To file rejoinder. To the contract filed by the.
Director of secondary education. Respondent number 2.
By the respondent. Please allow. Please not.
My lord, I pray for that, my lord. Other matter is not listed.
2 weeks is the matter again on. 12th September. Mr.
S. Mukhtar.
S. Mukhtar will consider this respondent.
I am for the respondent number 1, 2, and 3, my lord.
And Mr.
You, Sharma?
Sharma, then standing counsel. Secondary for the respondent number. For respondent 1.
120.
120.
Right. 33.
May please, Your Lordship. My lord, the petitioner has been terminated from service. He was a professor of my lord KK Handy, Open University. By violating all the norms of service jurisprudence, he has been terminated, my lord. And this honorable court was pleased to pass an interim order not to fill up the post. And my lord, time was granted for filing affidavit, my lord. Without the affidavit, it will be difficult to decide, my lord. My prayer would be, my lord, let them file the affidavit within a short time, my lord.
Yes. But you will file an affidavit within a week, your lordship.
Very good.
Very
Very
good. Heard Mr. M. K. Chowdhury, then the senior counsel.
M. Sharma.
M. Sharma, then the counsel. Also heard Mr. T. Chamar.
But I'm not there. I'm standing for making a mention.
Okay. Mr. A. Ahmed, then the standing counsel.
KKHSOU.
KKHSOU. Place for weeks time to file counsel.
Let it come after 2 weeks, my lord. In the meantime, my lord, if
after 2 weeks.
Obliged.
But I'm sorry to disturb your lordship.
praying for an indulgence, my lord, to make a mention of a listing of a matter tomorrow, my lord. I'm sorry, I could not make a mention in the morning.
Why?
My lord, the person is prematurely directed to be retired in 31st August.
So we have time.
If your lordship not inconvenient tomorrow, then
Monday.
Monday, my lord. Can it be on Friday, if not inconvenient? Obliged.
I'm grateful.
13 of daily leave, motion.
Lordship, in this matter, the petitioner who was working as a Hindi teacher since the year 2013, regular appointment, has been terminated from service in the year 2023, questioning her qualification, and that too by an authority who has no jurisdiction under the law and without following the procedure prescribed in law. If your lordship peruses page 18, lordship, her appointment order at page 25, appointment order, 28 June 2013, her initial appointment. Page 25, appointment order dated 28 June 2013. Her name appears at serial number 1. Several others, she was appointed at Mahatma Gandhi MES, this was an ME school. And the school was amalgamated with a high school in the year 2017. If your lordship peruses the document at page 48.
Yes.
48. This is the letter written by the Commissioner and Secretary to the Director of Secondary Education. Amalgamation of school located in the same campus under the Shiksha Kshetra scheme for amalgamation of school. And the schools which are proposed to be amalgamated, lordship, the second paragraph, name of the school, Mahatma Gandhi ME School. This was the school in which the petitioner was appointed in the year 2013. And the school, high school in which it is amalgamated, Mahatma Gandhi High School. So in the year 2017, the ME school in which the petitioner was appointed in the year 2013 gets amalgamated with the high school. And by virtue of the provision contained in section 28 of the Provincialization Act of 2000, earlier 2003, now 2018, the employees of the ME school becomes the employees of the high school. That is, from the Directorate of Elementary Education, they come under the purview of the Directorate of Secondary Education. So by virtue of that, since 2017, the petitioner is an employee of the Directorate of Secondary Education. And in the year last year into 2022, she received a show cause from the District Elementary Education Officer at page 41. Very surprisingly, page 41. Page 41, a show cause on 4th of November 2022. With reference, and this person, he has no authority to issue a show cause. With reference to the subjects cited above, hereby asked to submit show cause reply of the following points: that you have misled the authority by submitting irrelevant documents related to a qualification for appointment as Hindi teacher, that you are not qualified for Hindi teacher of upper primary schools as per the advertisement published by the Director of Elementary Education Assam dated 19/11/2012. After more than 10 years, they allege that I have misled them. And the authority who has issued the show cause is the District Elementary Education Officer. He is an officer under the Directorate of Elementary Education. He has no purview of the services of the employees of the Directorate of Secondary Education. And moreover, even if a disciplinary proceedings is sought to be initiated, that has to be done by the appointing authority as per the service rules. And the appointing authority, originally though the appointing authority was the Director of Elementary Education, but the moment she became an employee of the Directorate of Secondary Education, the Director of Secondary Education steps into the shoes of the original appointing authority. So it is only the director of secondary education who can initiate, issue a show cause notice and initiate disciplinary proceedings. And thereafter, after this show cause notice was issued, she replied to this. Her reply is at page 43. Of course, she denied because she had never misled them. She had all along submitted all her documents, all her qualification, etc. And only after proper verification, the appointment order was issued. This reply is at page 43.
Then what happened?
Yes, after that, they issue a termination order at page 46. Page 46 is the termination order. This has been issued by the Director of Elementary Education. Page 46 is the order. Order dated 29/7/2023. The Lordship peruses the findings. As per the report and documents, it is found that though Srimati so-and-so did not possess qualification approved by NCT, yet she was appointed as she misled the authority by uploading documents of qualification which are not approved by NCT. She did not possess the qualification of degree with Hindi as one of the subject, which is mandatory as per guidelines of NCT. So-and-so has been working in Mahatma Gandhi MES, now amalgamated as Mahatma Gandhi. Lordship, I'm not even presently, I'm not going into the merits of the allegation which has been read. Whether the qualification of Hindi in graduation can be insisted on, that is another aspect. Now, nowhere the NCT prescribes that there has to be a subject of, one has to possess Hindi as a subject in graduation. Nowhere NCT stipulates that. That is why even in the termination letter, nowhere in the show cause notice they have issued, you have violated this such and such regulation of the NCT. Nowhere they have stated. And this order, this termination order was forwarded to the District Elementary Education Officer, Lordship, if your Lordship peruses the next page 47 on 9/8/2023. Only then I received it. The order dated 29/7/23 on 9/8/23.
Yes.
One more aspect, they cannot now at this stage say that I have misled them with my documents on it. Because after my appointment, there was a court case some other person had filed, and during that proceedings also, I was called with my documents for verification. If your Lordship peruses the document at page 60, the last page of my petition.
Yes.
Last page, I was directed to be present with all my documents. With reference to subjects cited above, this District Elementary Education Officer had directed me to attend the office of the district officer on such and such, along with original qualification certificate, appointment letter, joining report, working certificate, etc., for verification in connection with Honorable High Court case in number so and so. At the time of appointment, they verify my documents, my credentials. In the year 2015, again, in connection with another High Court matter, they verify my credentials. And now in the year 2023, they say you have misled us by submitting false documents, showing false documents regarding to your qualification. And show cause notice has been issued by an authority who has no authority, no jurisdiction to show that. And lastly, the termination order. The director of elementary education, she does not have the jurisdiction, because I am not under the purview of the Directorate of Elementary Education now. So on that ground itself, Lordship, the whole thing goes, even without going into the merit.
Lordship will find the appointment order. The appointing authority admittedly was the Director of Elementary Education, then Miller.
That relevant point of time.
At that relevant. After the amalgamation, Miller, their services are brought under the purview of secondary education. That's no dispute to that. Lordship will refer to Rule 28 of the 2018 Act.
Page?
Page 44 of
page
that.
44.
Oh.
44. Subrule 2, Miller, will be relevant. In case LP or MB, ME school or both amalgamated with a high school, all teachers and other staff of LP or ME, both schools shall be the employee of the amalgamated school and their services shall be at the disposal of the secondary education department. Only the services has been placed under the disposal of the secondary education department. That does not, my lord, take away the appointing authority. That was the initial appointing authority who has appointed her. The rule 9, my lord, says appointing authority. The definition in the Assam Service Disciplinary Appeal rules, it says, my lord, the authority who appoints the employee.
Yes.
So, my lord, in that, under such circumstances, my lord, the director of elementary education, being the appointing authority, has the jurisdiction to pass the order, my lord. That's my humble submission. Second, my lord, on the regarding the allegations and the other thing, my lord, possible issue notice will file our affidavit. In any case, my lord, the termination has been done.
So what about the prima facie rule 9 of the discipline appeal rules 964 has not been followed? That they have to follow.
Whatever it is now, the termination order. has
Yes,
been
absolutely,
passed.
yeah.
So it will be difficult to pass an interim order.
Because that would amount to a final relief.
But MSD Bogo and then concept of issue notice. Mr. B. Kaushik, standing counsel. Secondary education. Appears for the respondents, 1, 2.
I'm appearing for all, my lord.
Four.
1,
Appears
3, and
on behalf of
4.
all the
Both
respondents.
secondary and elementary.
Notice and responses are complete. However, extra copies. Respondents are notified contract. List after 4 weeks.
15.
Here, the petitioner, he is presently working as a SI, a sub-inspector of schools in the district of Nazira. And his grievance pertains to parallel continuation of the criminal proceedings and the departmental proceedings. The departmental proceedings arises out of the same set of facts. In fact, there's an FIR lodged by him that he had sought for some bribe from an employee. That was the allegation. After that, he was arrested, placed under suspension. Now, suspension has been revoked. He has been reinstated back in service. Now, the criminal proceedings is presently pending. Trial is presently pending before the Court of Special Judge Assam. The charge has been framed. It's in the evidence stage. Now, here we had submitted a representation before the authorities that since the criminal proceedings and the departmental proceedings arises out of the same set of facts, same evidence will be required. So it will be advisable in terms of this Honorable Apex Court's decision also that the departmental proceedings may be stayed till finalization of the criminal proceedings, because he will be prejudiced. And moreover, even the departmental, the authorities will not be able to properly adjudicate upon the departmental proceedings because the entire relevant records are there before the Court of Special Judge. And moreover, if the departmental proceedings are proceeded ahead with, he will be prejudiced because he will be forced to divulge his defense also. That is, so relying on the Lordship Apex Court decisions in Paul Antony's case, Lordship, wherein the Honorable Apex Court had held that if the same set of facts are there for the criminal as well as the departmental proceedings, it's advisable to stay the departmental proceedings. Whether they can will be able to take a call on that. That is my only. If your Lordship peruses here,
Yes.
the FIR, Lordship, at page 27. Page 27.
Yes.
5/12/2021. This was the FIR lodged. Allegation, as I already submitted here, that there was an allegation of demand of bribe of 15,000 rupees. And after that, he was arrested, then placed under suspension at page 31. Page 31 is a suspension order. By order dated 15 December 2021. Hereby placed under suspension.
Yes.
Then reinstatement order in the next page at page 32. On 6th of December 2022, suspension has been revoked and he has been reinstated back in service.
Yes.
Then the criminal, so far as the criminal proceeding as already submitted, charge was framed on 23rd of June 2023 at page 33. Page 33. Charge has been framed under section 7 of the Prevention of Corruption Act. Page 33 to 35. Then here at page 36 was the show cause notice which was first issued. Here again, this was issued by the district elementary education officer who has no jurisdiction to do that. So again, they have again issued a second show cause notice. The director of elementary education has issued now at page 41. Page 41 on 5th of July 2022.
Yes.
When we object to that, page 41, by the director of elementary education. And we have replied to that. And we have also stayed for at page 42 is the representation which we have filed, praying for staying the departmental proceedings. That as the departmental proceedings and the criminal proceedings are arises out of the same set of facts, same evidence. If your lordship, I would like to place the decision of the Honorable Apex Court, 1993 PSCC. Paragraph 21. Okay. Paul Anthony versus Bharat Goldmine, so he case to 93 case. It will break. I think principles like it will follow correct. Inspector itu kuibe itu konsep notice fiction নকৰাকৈ কৈ আনিবা নেকি instructor যদি নহয় তেতিয়া notice issue কৰি পেলাই চাব স্পেশাল ডাটা ফটো আজিকালি বিভিন্ন পায় সেইকাৰণে বহুত
Yes. Lordship will find the allegations which are level in the page 27. But Lordship, I feel it constitutes serious misconduct, my lord. And to my understanding, my lord, there is no bar for both the proceeding to proceed, because this is not a case where, because of the pendency of the criminal trial, the documents or something has been seized and the department cannot proceed, because it is the complainant who has complained. He has to be inquired.
But both the criminal and the departmental proceedings are going on the same allegations.
Set of allegations. Otherwise, the moot question which calling for your lordship adjudication, whether this both can parallelly proceed or not.
But Mr. NSD Bogwan and counsel for petitioner, we should not miss. Mr. B. Kaushik and standing counsel. Elementary education, I place on behalf of all respondents, notice and respondents are complete, extra copies. Respondents are to file contract private. List of the 4 weeks. In the interim, the departmental proceedings against the petitioner shall remain suspended till the next return.
How much?
Admission. Not please, Your Lordship. Some instruction was called from an earlier question. Your Lordship. My name selected to the SLC, Your Lordship. 34. But rejected due to non-availability of the vacant post, Your Lordship. Page number 37, Your Lordship. Serial number 11, Your Lordship. Relevant portion.
When was this DLC held, SLC?
Page number 18, Your Lordship. 5/6/2017, Your Lordship. Annexure 6, page number 18. Main page.
Yes. There you go.
My lord, instruction is awaited, my lord. Otherwise, notice was issued, my lord.
What instructions is required here?
Yeah, no, not necessary actually, because 2017 was rejected due to lack of vacancy, my lord. So nothing remains, my lord.
Lordship, my only prayer, Your Lordship, if the vacancy available, Lordship, I may be allowed, Your Lordship, to consider, Your
You
Lordship, to
can
place my.
consider the vacancy in some other department. That is provided in the OM, isn't it?
My lord. But
If the vacancy available, Lordship, only direction, Your Lordship, to place me before the DLC, Your Lordship, my case.
it was DLC, my lord,
It hasn't been rejected. Page 37.
no, no, no. My lord, was recommended for junior assistant post, my lord.
That's why.
My lord.
Apart from that, you can consider him for some other post.
Can be done, my lord, forward, but whether in state level committee meeting, my lord, because all the recommendations from the district level committee meetings are considered, my lord, in state level committee, my lord. So probably that was considered, my lord, in other departments also. Only in case of district level committee, my lord, various departments of the district, my lord, that other things come,
It does not say anything.
my lord.
Page 14, Lordship, Annexure 4. This is the DLC. My name is page number 7. Serial is 7, Your Lordship. Page 14. Serial number 7.
Junior assistant.
Lordship.
You reconsider again.
Lordship.
If it is not junior assistant to any other grade, to any other post, commensurate to his educational qualification. What, Mr.
AAR Karim, Your Lordship.
AAR
Karim.
Karim. Then council for petition.
Subject to availability vacancy.
Also heard Mr. U. Sharma, then pending council.
Secondary education.
Secondary education for respondents.
1, 2, and rest.
1, 2,
And 4. And 4, my lord. 4, 6.
1, 2,
6.
4, and 6. And Mr. G. Beku, Lieutenant Governor for respondents.
3 and 5.
Stop. Para. The father of the petitioner. Let Lila conduct Bora while serving as headmaster of Borjan Matipula Higher Secondary School in Golaghat district, died in harness on 17/3/2012. Stop. Thereafter, petitioner made an application for appointment on compassionate grounds. Stop. The case of the petitioner was considered by the concerned district level committee. In its meeting held on with the DLC minutes.
DLC meeting held on 16/11 of 2015, Your Lordship. Case
11, 2015.
Held in the drafted DLC
11/11, 2015, Your
in
Lordship.
its meeting held on 11/11/2015.
Case 14.
Recommended the case of the petitioner for appointment to the post of junior assistant. Stop. The state level committee in its meeting held on 5/6/2017. However, rejected the case of the petitioner on the ground of non-availability of post. Stop. A perusal of the minutes of the state level committee dated 5/6/2017 does not indicate that they have met, that they have applied to mind, taking into consideration clause 15 of the OM dated 1/6/2015. But clause 15 of the OM dated 1/6/2015 provides that if sufficient vacancies are not available in any particular office to accommodate the persons in the waiting list for commissioner appointment, comma, it is open to the administrative department of the office to take up the matter with other departments, public offices of the government to provide an early appointment on compassionate grounds to those in the waiting list. In that was the matter, comma, and after perusal of all the matters available on report, the matter is remanded back to the state level committee to reconsider the case of the petitioner, particularly in terms of clause 15 of the OM dated 1/6/2015. Stop. It is also made clear that if there's no post of junior assistant available, the petitioner may be accommodated to any other grade 3 or grade 4 posts commensurate to his educational qualification. The said consideration of the petitioner shall be taken up in the next immediate sitting of the SLC. With the above observations and directions, with petitions disposed of.
Obliged.
35.
May I please, Your Lordship? Well, this matter is pertaining to provincial election service of the petitioner as LP school teacher, Lordship. My lord, earlier I approached before this honorable court, and this honorable court, Lordship, directed the authorities to consider the appeal filed by the petitioner, Lordship. That has been, Lordship, came to be rejected. If your Lordship kindly come to page 50. 50, Lordship, rejected on the ground that there is a mismatch of dice data, Lordship. Lordship, if your Lordship kindly come to page 50 is the impugn order, and Lordship, just middle, Lordship, may I read this page 50? Accordingly, the issue was, Lordship, whether the name of school appear in dice data maintained by so and so of 2009 or before, whether name of incumbent appear in dice data of 2011 and afterwards, enrollment position of the school during 2016-17 and 17-18. Accordingly, the ASS Assam had verified the above mentioned points and submitted the report of dice data so and so with comment in remarks column as dice 2006-7, 7-8 and 2008-9. The school against dice data is found. In dice data 2019, the school name is not there. But since 2010-11, dice till date 2017, the dice code has been changed to so and so instead of so and so. Lordship, last digit, your Lordship kindly come. In the initially it was, Lordship, last digit was 2, but that has been changed to 5. After that is, Lordship, 2010-11, and because of this, Lordship, our claim has been rejected. Lordship, I have obtained the detailed information regarding the dice through RTI. That is, your Lordship will find at page 51. This is the RTI reply, and relevant, Lordship, page 52.
Yes,
Lordship.
Chowdhury.
Lordship, I'm appearing for SSA, Lordship. I have received the instruction. Lordship may grant me 2 weeks time to file the application.
Heard M. Khan, then counsel for Mr. B. Chowdhury, learned standing counsel SSA submits that he has received instructions and prays for 2 weeks time to file contempt. Praise Allah. Please submit.
Date may be given also because this is the second application.
It will come up. It will come up. It's
After-
coming now this will come up.
26.
Yeah, please. Lordship, in this repetition, Lordship, I challenges the selection and appointment to the post of assistant teacher LP school under Hailakandi district, my lord. I participate in the selection process, my lord. My subtotal of marks, my lord, 205.47, my lord. And cutoff marks is Lordship 204.63, my lord. My subtotal marks is more than the cutoff marks, my lord. I am entitled to selection, my lord.
Yes.
I'm awaiting instruction.
You heard, Mr.
H.L. Ashkar, my lord. H.L. Ashkar.
H.L. Ashkar. Mr. G. Beku, then standing counsel,
Elementary.
elementary education, prays for
3
2 weeks time to receive instructions.
Lordship, affidavit also may be directed to file. Most of them.
37. Order.
May I please, Your Lordship? My lord, it's in 2017, my lord, order, my lord. Regarding, my lord, non-payment of salary, my lord. Order is Lordship.
37, my lord, may I just pray for an accommodation on behalf of Mr. N.J. Katunia. He is not here today. Let we can take up next week, my lord. I guess.
Yeah, no, they have been, my lord, it's a 2017 matter, my lord. My lord, last 5 years.
Tanya is handling the matter.
And otherwise also, my lord, the respondent, my lord, Dr. Vijay Chaudhary, he is no more there, my lord. Probably they will have to file an impediment.
My lord, I have already filed, my lord. I have already filed, my lord. I see here, my lord. I number, my lord, 2413, my lord.
1 minute.
Earlier incumbent, my lord, respondent number 3, my lord. Dr.
Vijaya Chowdhury is now what?
Limited.
She is no more there, my lord. She is on leave for ailment, my lord, for a long time.
Now, my lord, Narayan.
Now, Narayan 4 has come on.
my lord. He has been implemented now, my lord.
Where?
They file an application
We
for
have already
replacement.
filed application, my lord.
Where's your application?
Application is there, my lord, in the airport. I number, my lord, 2413, my lord.
Secretary.
Secretary, my lord.
He is the new incumbent.
In place of?
Dr. Vijay Chaudhary.
Earlier, my lord, yes, respondent.
Respondent number 3.
My lord.
Yes, of course. Elementary.
My lord.
Elementary.
The Secretary of Department of School Education.
You have two secretaries, elementary. One is Surajana Senapati.
Suranjana Senapati is Director of Elementary.
He is, okay, director. of
Director.
elementary. Then we'll dispose of this.
Mal-
Working with you.
First, Lordship can dispose of this.
But Mr. D. Boyan and the council for the applicant. By this application. The applicant is praying for impeachment of Sri Nayan Konwar, Secretary to the Government of Assam, Education within bracket Elementary Department. As party responder number 5
madam.
in contempt case number
124, 2018.
124 of 2018. On the ground that the respond number 3 in the contempt case has been is on leave. And the proposed incumbent has taken over as the secretary of the concerned department. So, considering the submission made, pray for impeachment is allowed. IS disposed.
As per order dated 7/8/2023, my lord. Lordship may see 7/8/2023. The respondent number 4, my lord, was directed to submit a compliance report, my lord.
Yes.
As per my lord, order dated 7/8/2023, my lord.
Okay.
Let
Anyway,
notice
so
go on, my lord, in the new
in view of the order passed within the in ISO and so, let's so and so be instituted as party is on number 5. In the
5.
present contempt petition. Petitioner is directed to file and to file a amended cost title. Stop. This the matter after 1 year.
Lordship, kindly fix the date.
This the matter again on.
Sorted and given.
Perhaps notice will also have to be issued.
Notice will go only after he files. the
My lord.
amended cost title. You file your amended cost title after that I'll issue.
A pleasure.
38.
My lord, order of 9/11/2018, and the order was to be complied with within 3 years. We filed this contempt petition on 26/8/2019, and they are yet to comply with the order.
Mr. K. Gogoi was dealing with this matter, my lord. As I have been informed, my lord, this matter is pending before the government, and government is considering an enhancement of their salary, my lord.
This was the instruction given in the last 2 days also.
I've been,
Where's Mr. Gogoi?
my lord, I think he's not in court right now, my lord.
Means, in the record, I think the last communication is there, my lord. They have placed one communication in the record, I think.
Another 3 weeks, my lord, I'm seeking 3 weeks for.
In the meantime, my lord, what has happened after 2018, some of them have retired also. They are also waiting for the compliance of this order. The court has asked them to give them the regular pay, basic scale of pay.
Then what is so difficult? 2019 matter.
My lord, as per
9/11.
instruction, my lord, it is under consideration, my lord.
Since when? Okay, we'll fix a date. Look, Gogoi come.
My lord, the direction was at page 28, my lord. The respondents are directed to pay to the petitioner the basic scale of pay, including the areas with effect from 22/1/2015, within a period of 3 months from the date of receipt of the certified copy of this order. After that, my lord, they are processing only 3 months has long passed. And we filed this contempt petition in 2019.
But Mr. D. Conwar and the senior counsel assisted by Mr. J. Singh and the council. On request made on behalf of Mr. K. Gogoi, the council for the respondent number 4 and 5. Please the matter again on when?
2 weeks, my lord. 2 weeks, my lord.
8th of September.
13th.
13th of September. Let it be on 14, my lord, subject to your lordship's convenience, my lord. 14.
39.
May I please, your lordship? This is the contempt matter notice was issued on 5/12/2021, my lord. No affidavit have been filed, my lord.
But to allow me some time to file my PTP, if there's some positive development, my lord. If we post in the middle of September, my lord, that order will be complied, my lord. Therefore, some positive development.
14th of
Heard Mr. Bhuja Baral and counsel for the petition. Mr. S. Boral and counsel for the cell respondent submits that the case of the petitioners are under consideration and place for some time to enable him to receive instructions. The praise allowed. Is the matter again on? When?
14th, my lord.
14th September.
14th September.
Make it 15th.
Yes, my lord.
15th.
Master.
For P,
My lord, direction has been complied with. Order. Nepal, okay.
Where's the order?
We will not negated the claim. We have to silence it, Lordship.
Heard Mr. M. Khan and counsel for the petition. Mr. J. Bikul and counsel appearing for the respondent.
Sole respondent.
The sole respondent.
Well, not one thing is to be, the honorable court lordship has given a specific direction. Taking my appeal may be disposed of, taking into consideration to report.
That's why you'll have to challenge. it.
That has not been reflected.
Has produced an order dated 6th April 2023. Issued by the sole respondent. Whereby the claim of the petitioner school has been rejected. Stop. On the consideration of the order dated 6th April 2023. This court is of the considered opinion that substantial compliance has been made by the respondent. Accordingly, IA is closed. The order dated 6th April 2023 is placed on the court. The contempt.
21.
May it please your lordships. Lordship, the IA is for the implement of the respondent lordships.
IA number?
IA number 3092/2022 lordship. The newly appointed contempt notice was served to him, and by way of filing additional affidavit, we brought on the record of this court today, your lordship. So, filing slip with me, your lordship.
What are you looking?
Lordship, we served the notice to the contemptor, newly appointed contemptor. And the notice was brought into record by filing an additional affidavit, lordship, by today itself, lordship. So, lordship may issue notice to the respondent, your lordship, for the implement of the respondent lordships.
What is this IA for?
Implement of the respondent, your lordship. Earlier, contemptor was replaced by Secretary of.
Who are the respondents?
Respondent are Bijoya Chaudhary and Mamata Hosai, your lordships.
Both are not the.
Narayan Kaur and Mamata Hosai.
Where is Narayan Kaur?
We have filed the petition additional affidavit on today, your lordship. Filing slip with me, your lordship.
Additional affidavit in the IA?
Yes, lordship, we are on the last occasion.
Where is the IA?
IA is 3092/2022, your lordship.
I'm on that IA.
Yes, lordship. Then last occasion, we are directed to serve the notice to the newly appointed contemptor, your lordship. we have served the notice to the newly appointed contemporary, Your Lordship.
They have filed the IA without submitting any representation to the newly implemented lordship. So now they have submitted that representation.
To whom did you submit the representation?
Representation submitted to newly appointed contemporary, Mr. Narayan Kaur and the Director Mamata Huzai, Your Lordship. And these things we brought on record by filing an additional affidavit, Your Lordship, today.
Yes.
So I have filing slip, Your Lordship.
Lordship with the record.
Lordship may call for the record by fixing a date, Your Lordship, or relying.
Additional affidavit
Yes, Lordships.
dated
Dated
Filed today, they have said.
23/8/2023, today itself, Lordship,
showing what?
showing newly appointed contemporary.
Showing that they have submitted the representation, informing the newly that they are supposed to be implemented as a respondent. The representation, their intimation they have submitted.
But this IA is something else.
This IA is for the implementation of the contemporary, Your Lordship. Kindly
They
peruse
have
my.
filed the IA without intimating the present incumbent. That is why now subsequently they have taken the steps to intimated the respondent.
No, that is not the thing. This IA is for implement of.
Respondent number 3 and
Name.
the name Vijaya Chaudhary and Mamata Huzai, Your Lordships.
So now
So
they
now-
want to replace Vijay Chaudhary.
So this has become infracture.
Yes, this is becoming.
Lordship, she is in place, but she is on leave now.
In her place, there's somebody already serving.
Yes, Lordship, but newly appointed secretary, also we have served a notice.
That's why you should file an IA now
Separate IA file to
for impleting that so and so.
Separate IA file to
Lordship.
So you can withdraw this or we can close it as infractions.
Lordship, I'll do this petition, I will file the new.
That is, all right, that's fine.
Yes.
Mr.
S.A. Borgo, Your Lordship.
S.A. Barwell and the counsel for the applicant prays for withdrawal of the present IA with liberty to file appeals.
Lordship, deeply obliged, Lordship.
Praise allowed, IA is dismissed and withdrawn with liberty as paid.
Deeply obliged, Lordship.
42.
My lord, this is an application on the order 9, rule 4 of the Code of Civil Procedure Code for the restoration of miscase number 21/23, recalling the order dated 27/6/2023. My lord, in the miscase, petitioner could not appear in 2 days due to the illness of the advocate. That's it. So the case is dismissed by the order dated 27/6/2023.
Contempt case was dismissed.
Yes, there was one contempt case mainly. Main contempt case is 139/2018.
Correct.
That contempt case was long pending, but after pandemic situation, there is non-communication with the parties, and that contempt case is dismissed due to non-prosecution of the contempt petitioner. For this reason, we have filed, the petitioner has filed the miscase number 21 for restoration of the contempt case.
Miscase number?
21/23. But that miscase also is dismissed for non-prosecution for the illness of the advocate.
Okay.
Yeah. So kindly, this petition is praying for restoration of the miscase 21/2023. My lord.
Which miscase? 61?
This miscase is 61/23, but the previous miscase is 21/23.
Yeah, this one is 61 is praying for restoration of 21, correct?
Yes, my lord.
See your cost title. First page.
Yes, my lord. An application on the order 9, rule 4 of the Code of Civil Procedure, paying for restoration of the miscase number 21/23.
Read further on.
And contempt petition being contempt case number 6139 2018 by recalling the order dated 27/6/2023. That
Is
is
that possible?
so no, my lord.
Is that possible?
No, my lord. This miscase is for restoration of the miscase number 21/23, my lord.
Then why have you stated contempt petition? Once I allow this miscase, automatically contempt petition will come,
Yes, my lord.
will stand restored.
I will correct that, my lord.
You file afresh. Withdraw it and file afresh.
I will correct, my lord, that.
You can't correct it. You'll have to file an application for correction.
Oblige me.
So instead of filing an application for correction, you withdraw this IA and file afresh. That is much better for you, isn't it?
No,
Otherwise, you'll have to file an IA correction. After that, amended application.
Yes, my lord, I will correct, then I will file an application, my lord.
Then you want to withdraw this.
No, my lord. I have to correct this one only.
So you'll have to file an IA to correct this misapplication.
Okay, my lord.
After that, you'll have to file an amended misapplication. 3 steps.
Oblige me.
So better you withdraw this, file an IA, and then you'll have no, you're saving your time. That's what.
But there will be time limitation, my lord. There will be time limitation.
Time limitation, what time limitation? You can explain everything that this was filed, there was something wrong, it was withdrawn. For that, there's no time limitation.
Okay, my
It's up
lord.
to you. If you want to file an IA, it's up to you.
Okay, my lord.
What do you want to do?
I will file fresh petition, please.
So you want to withdraw this?
Yes, my lord.
Okay. Mr.
Laban Kolita, L Kolita.
L. Kalital and counsel for the applicant, press for withdrawal of this present miscellaneous application. With liberty to file a fresh. Praise the Lord. Which application is different from withdrawal with liberty as well. That is in Mr. 51.
43.
My lord, this case also non-compliance with the order, my lord. But my lord, respondent number 1, my lord, she got sick, my lord. So accordingly, we have sent a legal notice for intimation, my lord. So matter may come up some other day. In the meantime, we'll file our IA, my lord. Completing your
Mr.
person.
Jay Barboel and counsel for petitioner, press for
10 days time, my lord.
press for 2 weeks time. To file an application for improvement of necessary parties.
Plus.
Press list of 2 weeks.
Okay.
44.
With legal lawsuit, this is a contempt petition lawsuits. I have come against the order dated 28/10/2021, my lord. Relevant portion is page 14, my lord. It
Yes.
starts from page 3.
Oh.
Para 3, page 13.
Yes.
So notice me go at this stage, my lord.
You filed this contempt petition under which provision of law?
Section 11 and 12 of the Contempt of Courts Act 1971, read 215 of the Constitution of India.
Okay, otherwise there's a limitation to it.
No, my lord, this is they have given 1 year time. That's why the lawsuit kindly peruse the requirement be done within a period of 1 year from the date of receipt of the certified copy of the order.
One year.
1 year. That's why. my lord.
Heard Mr. MS K. Devi, then the council. Issue notice. Petitioner to take steps for service of notice. On all the, on the respondents.
Yes, my lord.
1 to 5. By.
1 to 5.
This took 6 weeks.
Highly obliged.
46.
Please, Lordship. Lordship, this contempt petition has been filed against non-compliance of order dated 24/8/22. Lordship, relevant portion is in page 26.
Did you file your representation?
Yes, Lordship, we had filed on 38/22
38.
in the Lordship, page number 27, next page itself. And we are also
Yes,
called for
heard-
hearing.
heard Mr.
NZ Chaudhary.
M. Chowdhury, the council for petitioner issue notice. Petitioner to take steps for service of notice on the sole respondent by registered post ID within 1 week.
All right.
Is the matter of the 6 weeks.
Ashok Lordship.
47.
May I please? Lordship, I am irregular teacher, my lord. My service was accommodated as tutor, my lord, by the order dated 23 September 2022, my lord, annexed 12, page 44, my lord.
Why is this coming for orders? to you? Notice,
Order.
notice on private respondent.
Yes, my lord.
Has it been
Notice was
served?
completed, my lord.
What are the respondents? 6 and 7.
Yes, my lord.
Anybody appearing 6 and 7? Nobody. But Mr.
H.L. Ashwin.
H. L. Laskal and the council for the petition. Peruse the proceedings of the Lahozama court dated 1/6/2023. The notice on respondents 6 and 7 shall be deemed to be complete. List the matter after 3 weeks in the application court.
Most of it.
48.
May I please, your lordship, sir? I am appearing on behalf of Mr. R.S. Lamala. In this case, objection petition have to be filed, Malak. Therefore, 2 weeks time, maybe.
IA.
IA, in IA.
What is this IA about?
My lord, this is for default, my lord. Subsequently, my lord, earlier date filed the objection, my lord. 19 days delay, my lord. My lord, either miss case, my lord, IA number 1515. My lord, this condemnation of delay, my lord, 19 days. And my lord, this my case was dismissed for default. I filed the miss case 40. And thereafter, my lord, this condemnation of delay 19 days, my lord. And on the part of my fault, my lord, I could not appear before this honorable court, my lord. This part 2 hearing list, that time, my lord, I am going to my native village. I look after my mother illness, my lord.
Okay, heard Mr.
Jad Hussain.
Then counsel for the applicant. Mr.
Ziu Ahmed.
J.U. Ahmed, then the counsel appearing for the opposite party number 7. Press for how much time?
2 weeks. My lord, earlier occasion, already
To
time.
file objections. List the matter after 2 weeks. Last time also you've been given time. If you don't file your objections,
So it definitely fine. My lord, date may be fixed.
it will come up, it will come.
Otherwise,
49.
May please the lordship, my lord, this IA is for amendment of the writ petition because of the subsequent developments. My lord, the petitioner has got a checkered history. About 30 years back, my lord, he was appointed as the LP teacher. But after about 3 months, his salary was stopped because of the reasons that there was a Monoholam committee report that he was irregularly appointed. But in 2005, the government decided by cabinet decision to regularize the services of 125 numbers of teachers. And petitioner was one of them. But in 2006, that was in 2005. In 2006, he was regularized and allowed a school to join. Ultimately, he joined in the school, but he found that the post was not vacant. It was filled up. That continued about 4 years. In 2009, he was then adjusted in a different school. But the proposal was not given effect to on the basis that there was an interim order of this honorable court. And in that way, my lord, in 2010, he had filed the writ petition. But in 2021, my lord, he was accommodated as a tutor under the new regulation, new act, 2017 act, but with a condition that he will not be given any back wages or that it will be had prospective effect. Your lordship, please to see the last
No,
page.
but today is for consideration of your IA, isn't it?
Aye.
For amendment, who appears on the other side? Have you served copies?
Yes, copy sir. Copy sir to the government. I want to add the in paragraph 4 I have stated, my lord. Paragraph 4 of the amendment petition I have stated. Capital A, B, C, D.
Yes, secondary education, finance.
Amendment may be allowed and the petition may be posted for hearing. Either if the amendment is.
Allow this IA, you'll have to find your amended application.
Yes, yes, sir.
With petition. But then subject to any objections from the
Yes,
other
yes,
side.
yes, yes.
Instruction under that record is not with us no, since 2010, whether the amendment petition when it was served.
It's a matter of 2023 IA.
এখন তো স্কুল এডুকেশন নাও ইট ইজ স্কুল এডুকেশন এলিমেন্টারি
Elementary file আছে না record আছে না
now it is everything is amalgamated. Now it is nothing is possibly elementary and or high secondary.
No, director level there is there. On the government level, it is ML. Director level, secondary element is different.
Finance. Elementary education.
Elementary topic, yeah, I get the record.
You have-
Finance is not there. Their name is also not shown in the code.
Your name is shown, standing council finance.
It is shown, yes. Regarding amendment lawsuit, let me take instruction from the department lawsuit at this stage. After 13 years lawsuit, it was filed in 2010.
Because the input order was passed in 2021. That I want to challenge.
Okay, heard Mr. BC Das, the senior counsel. Assisted by
IDAS.
IDAS. Counsel.
Scan করে পড়তে, এটা scan করে পড়তে।
Stop.
কি লিখবে?
Mr. S.M.P. Chishti, learned standing counsel.
Elementary.
Elementary education. Request for some time to receive instructions. List after
2 weeks left.
2 weeks.
पूरा चिट्ठी लिखा है स्कैन करा लिखे थे 50 पूरा समझे
Today it has come for orders for
Notice.
a private respondent has received it and there is a Lojima order.
Large order the 21/8, my lord.
Services
Notices on respondent 6 and 7 have been complete, my lord. So it is ready for admission, man.
court is
Yes, Mukhtar.
Mukhtar and counsel for the petition. Here is the order dated 28,
21.
21/8/2023. Okay, that was in the court. It's done. The notice on respondents 6 and 7 shall be given. List the matter in the admission column after 2
2 weeks.
I'd like to meet.
Not really list order.
Made page, your lordship. My lord. I tried to find out solution, my lord. In place of 11, if your lordship, my lord, put 4, then it will be a clerical mistake. If it is a clerical mistake, that can be corrected by 362.
Give me CRPC.
362.
But if that was the consideration, the period of incarceration was the consideration for ultimate letting them out, then lordship have perhaps cannot. But if it is an error apparent, nothing needs to be done. Lordship need not go into the merit. Then lordship can correct it.
As per 362, has your lordship got it? No court to alter judgment, save and otherwise provided by this code or by any other law of this time being enforced. No court, when it has signed its judgment on a final order disposing of a case, shall alter, review, or send except to correct a clerical or arithmetical error.
Clerical.
Clerical and arithmetical. Suppose, my lord, there is arithmetical. Only that case, my lord, that can, otherwise, after signing is fantas officio, my lord, it cannot be.
Otherwise, judgments, I'll read out few lines. What is clerical and arithmetical error? A clerical or arithmetical error is an error occasioned by an accidental slip or omission of the court. It represents that which the court never intended to say. But here is a case, it's not intended to say, lordship in fact intended. Well, this is what. It is an error apparent on the face of the record and does not depend for its discovery on argument or disputation. An arithmetical error is a mistake of calculation, and a clerical error is mistake in writing or typing. Of course, this is an arithmetical.
Mathematical or you can calculation.
Calculation mistake. And it's an error apparent. Because record shows they were not there for so many years.
So it's a, obviously.
But the amicus curiae, they have submitted that they have been detained in custody for last 11 years. On that basis, we have passed the judgment.
But I had checked and I had told your lordships that no, that was not the fact. These people were there for only 3 or 4 years.
4 years.
That was there. I had seen the
reported by the
video
jail
clipping
authority
also. Yes. I have seen the video clip and lordship had in fact written down.
That if it is, we might have taken it as a arithmetical error because of some, we have not, without the records.
Records. After seeing the records, I had said.
The period we said in custody and set off.
Because lordship has already converted it. So no minimum.
No minimum is prescribed in 3041.
So anything to anything. So
even in 2 years, 3 years, 1 year.
Like that, the period which they retain in custody.
Yes.
Shall be.
Then
No.
they will calculate the matter and release.
That can be.
No,
That can be.
That will be.
Who is that particular?
Yes. Only year if your lordship in place of 11, if your lordship put 4. More than 4 years.
If your lordship writes that what they were, whatever they were.
From the record.
They were there.
From the record, it is clear that both of them, both the accused are, they are more than 4 years in jail. One is 5.5, one is probably 4.5. Accused number 1 is in 4 year, 11 months, and accused number 2 is in 5 year, 1 month.
5 years.
So both are, my lord, above 4.
Which part? I'm not getting that part. Is it para 43?
Para 43.
43, my lord. Accordingly to the learned counsel for the appellant have served more than 11 years in jail. So now your lordship can convert it to 11, not 11 years, more than 4 years after peruse the record.
Then there is another line also.
That we
It
have gone through the
transpires.
lines here which revealed the case was committed to the court of session in 5/11/2001. Thus transpires that the appellant is in jail hazard for more than in place of 11.
Yes.
Taking into account fact and circumstances with the offense so and so, the modified the offense so
No,
Therefore, the-
already we cannot go for that. That is like arithmetical calculation. We have hold that that is 11 years. They have been jail in 11 years.
my lord. So if it is whole in 11 years, then my lord,
The period which they retain in custody shall be set up in that way. We can just, so they will calculate the matter and release them, whatever it.
But whether that will be arithmetical error.
that
because,
cannot be corrected, my lord, as per 362.
that will be like again, seeing the matter from a new angle. And that will be like. So 11 has to be changed to 4 or 3.
4
Minimum 4.
and 4 years
Four
minimum.
is limit. No, yeah,
Hmm.
But lordship has to again see whether 4 or 3 years are sufficient for a culpable homicide not amounting to murder.
30 for part 1.
Part 1, yes.
Part 1, no minimum is prescribed.
Minimum is not prescribed.
Minimum is not prescribed.
But if your lordship thinks, no, that is not sufficient, then it will not come within that arithmetical error. And they have to go to Supreme Court.
The whole judgment will change.
Change.
Whole judgment will change.
It's the court,
yes.
because after signing, but
It
Yes,
becomes
360.
not sufficient.
360.
cannot change. That is why cannot change. Yes, this. Only the number can change.
So I think the best option is from making it 4 instead of 11, because again, person will be, they will again say there is violation of 21, they'll have to again go and all that.
That is the problem, man.
Go to Supreme Court, there will be no remedy here.
এইটো আৰু পেৰুজেলত ৰেকৰ্ড সেইটো আহি যাব ৰেকৰ্ড চাই পেলাই দেখিলে চাই
Change it to 4.
3/4 that way.
It will be both, clerical and arithmetical.
both
It will be arithmetical error, no?
No, both.
because a clerical mistake also because you are calculating your wrong
Arithmetical or no, can be both or arithmetical. Wrong calculation. Has to again ponder, lordship has to think.
because law is very clear 362 only power now you can exercise the court can exercise here but that can be done only in case of arithmetical and clerical mistake.
Correct a clerical or arithmetical error.
Wrong in calculation also
Lordship
arithmetical.
can add, in fact, if I may say, lordship can add both arithmetical as well as clerical, because arithmetical because the number of years and the fact that it is written, clerical is, it is written that they have been for 11 years. That is the arithmetical, clerical mistake, and 11 to 4 is the arithmetic.
মই কৈছো এইটো
Yes.
Yeah, difference. There is nothing except that clerical or arithmetical, both will. one has gone only 4 years something.
No, it will,
This
it
was
will
the-
be aggravate it.
Already so 21 value there. Usually छोटी देखा ना इतना डॉक्टर
In his judgment, you have cited on the
And
earlier date.
Judge-
These are the judgments. The earlier date, the judgment that I had said was actually on, these two judgments are there. One Guwahati High Court, one Supreme Court. Supreme Court Lordship can write 81, 1 SCC 500. 81. 81, 1 SCC. 1981. 1981. 1 SCC 500. This is Suraj Devi versus Pyarelal. 500, no? Page 500. This is what, this is arithmetical and clerical errors that are just.
SC Suraj.
Suraj Devi
Suraj Devi.
versus Pyarelal, paragraph 5.
Suraj Devi parallel versus.
No. Suraj Devi versus Pyarelal, yes.
Versus.
another judgment will also can take.
Suraj Devi versus Pyarelal and.
My lord, another judgment,
Yes.
2019-10 SCC,
Okay.
2019-10 SCC 161,
161.
State of Madhya Pradesh versus Man Singh, para 7.
Versus Mansi.
Man Singh, M-A-N,
Man Singh.
man, actually Man Singh.
MANSINGH.
Man Singh. Para 60, para 7, my lord.
Let's have a look.
My lord.
CPC 1.
It is similar. Clerical net pity. Okay, 150. Only that. Otherwise, you know. That's it.
Jurisdiction to review its order, either under 362 or
Except-
352.
62 compares. It included arithmetical. I mean, record for who could it? Is it like?
Disposing of petition decided.
Who could it?
And
Not a
discussion
result.
of the case
So-
on. And I got.
Wrong calculation of record.
Becomes functional solution.
Hmm?
No. Expressly bars review and speedily provides a no court order it signed by the judgment. Except to correct.
Long reading of
clerical
record,
error.
calculation of record.
It's not clerical or error. That's nice.
Well. Yeah, we've also recorded the no. So what do we do? See, Jahan and Mahanda, read this para 47. Here we have clearly stated, according to the learned counsel for the appellant.
47.
My lord.
43.
43, yes, my lord.
The appellants have served more than 11 years in jail, Hazut.
Mm.
Then next line is very important.
We have gone to
What
the
they have
LCR.
said, Which.
Revealed that the case was committed to the Court of Session on 5/11/2011.
No, there is no mistake there.
There is no, committed is correct.
Continue.
Yeah, hence that it transpires that the appellant are in jail Hazut for more than 11 years. So my lord, for commit,
From committal to the date the judgment was passed, of course, is 11 years.
actually committal to Hariyapman Asil. He is not in jail for committed, because after that he
No,
was
he
getting,
was bailed
he
out.
was in bail out. Hence, transpires that the appellant are in jail Hazut for more than 11.
So
Hmm.
apart from changing the years or
Can it be clerical?
some more has to be added.
Can it be clerical or
No,
arithmetical?
clerical. This is
Very-
their submission. That is their submission of the amicus that.
But then that was clarified by me. So
On that day.
on that day,
Correct.
we had seen the video clipping. of- on that day.
That they were not in jail for
Huh,
last 11
I've
years.
seen the records and I've said. Here, standing here. After that, the mistake happened.
What is the solution now?
Solution, my lord, if we exercise the power under section 362, it has to be a clerical mistake or arithmetical mistake. So whether it can be, my lord, yes, your lordship correctly pointed out that if I go by the last middle line, then it cannot be said to be a clerical mistake. It will be slightly difficult.
So then what happens?
So then it will be, my lord, probably that we have no jurisdiction now. The Honorable High Court has no jurisdiction, my lord, after signing the judgment. As per, my lord, that the judgment also. Somehow, if we defend that is a clerical mistake, then only it will end your point.
They should go and appeal.
Total
They should go for
mistake.
appeal.
Total mistake.
I think Jahan, I think you should go for an appeal.
Appeal.
Against para 43.
Appeal means before the Supreme Court.
Supreme Court.
That's it.
Because subject to correction, lordship, I would of course like to submit. Of course, I got a decision on mistake of the court. If that can be applied.
That part, if you can bring something, then we can use them.
Mistake of the court, I got one decision on this one.
No, whether that
but-
mistake of the code within the purview of this 362 or not, that will come to the claim.
Hmm.
Because judgment person.
This is, of course, this is not on exactly 362, but 152 of CPC. Same clerical and
Same
arithmetical
power is,
mistake.
my lord, in CPC 152.
Ah.
152.
There, lordship can see 2001 4 SCC,
2001.
4 SCC, 181. If there is some mistake of the court. Jayalakshmi Koelho versus Oswald. This is a family matter. There,
Me?
Jayalakshmi Koelho, COELHO versus Oswald Koelho. There I found a paragraph on mistake of the Honorable Court.
1 second citation, 2001 4 SCC.
2004 1 SCC 181. Because filing of an appeal and all, everything will take lot of time. And there is already an order
To release forthwith. That is the
release
problem, my lord.
forthwith. We have to get a stay instantly.
আমি কিছু মুন্ডেশন মশাল খুব শিখিল আমি
Huh?
কেমন বলি
2001 no, এটা পাইছিলাম one.
Have it just an arithmetical error. Issue is
মিস্টেক অফ দি কোড বলেও তো কমন হয়
the appellants, they will not be accepted. But if you responded, they go for appeal, then will be caught. No? But if they don't go for appeal, then there's no issue. But you can ask them also.
So the paragraph, yes, the paragraph 14 of the judgment, I may just read out the short paragraph.
Jayalakshmi.
Jayalakshmi. So far legal position is concerned, there would hardly be any doubt about the provision that in terms of 152, any error occurred in the decree on account of arithmetical or clerical error or accidental slip may be rectified by the court. The principle behind the provision is that no party should suffer due to mistake of the court, and whatever is intended by the court while passing the order or decree must be properly reflected therein. Otherwise, it would only be destructive to the principle of advancing the cause of justice. A reference to the following case of so and so. So there can be a mistake of the court for which people should not suffer. This is what this said.
But that is
Ah.
152.
By 152. The same principle.
Same
Oh, same
principle, it is CPC.
CPC.
ইয়াতে অলপ লিখাই চাওঁ নেকি একে লাইনত যদি আমি চিয়া পিঠা এটা পাই গ'লে পাই যাম।
Oh, CPC point.
মই সেইটো প্লেন ময়ো পোৱা নাই মানে আৰু অলপ যদি হেৰি কৰি বাট এনি হাও মানে আমি ট্ৰাইকেলত আনিব লাগিব ট্ৰাইকেলত আনিব নোৱাৰোঁ সেইটোতো মই যিটো 19 দিলোঁ তাতে চিম্পলি কৈছোঁ ট্ৰাইকেলৰ এপ্লিকেশ্যন নকৰি ইকানা ঘৰটো অফিচ হৈছে এই চিটিতে ৰ'দত নগৰী সঠিক সেই প্ৰিন্সিপল যদি ক্ৰিমিনেলত আমি এটা পাওঁ
Criminal positive.
Let me
Yes. We'll fix another date for.
My lord, let me
for
see in that line if he get any in criminal side judgment, because that judgment is probably in civil 152 is very clear.
152.
Very clear, but in that, in respect of 362, let me research some homework, my lord, and fix another date. You will to see.
First, Mr. T.J. Mandal and others. Standing Council, Guwahati High Court.
And Ms. D. Saikia she is also for one of the appellant. She could not be here because her father is not well. He is treated in Delhi, so he is with him.
Also heard MSS John and the Education PP Assam. For the respondents, 1 and 2. The others,
For one of the appellant.
one of the appellant, which appellant?
What is?
Now, what is
3 and 4 in the IA. Have you got a copy of the IA?
No, no.
What is Kuzu?
Anil Kajur, Warish Kajur.
You
I
have-
think, Waris, no, Waris Chokan है
No,
Anil, I'm for Anil
Party
Kazur.
chap.
Anil Kul.
Hardly Majumdar.
2001, what did it wrong? That is good.
MSRT
This
Majumdar.
is good.
Then you had amicus curiae.
Yes, sir.
Then the amicus curiae for the respondent number 4. Stop. None appears for the respondent 3.
Because her father is not well.
That's,
Mr. Saikia is not.
Please the matter. When shall we have it? After a week, after 2 weeks?
After a week, there are holidays in between. So September 7, 8 or 11.
I'll be up.
Oh, September 11, 12.
3 to 13, I'll be done.
Oh. Then 14 September.
Is it okay for? Oh, you'll be in Itanagar from? From?
11.
Oh,
Okay,
from
14
11.
will be better.
Then
Then after 28th of September.
No.
After 20.
But they are inside jail now for so long.
Huh?
They are
Maybe
inside
next
jail.
week, They are inside jail.
So next week, Lordship can take it up on 28, 29.
30, 31.
No, my bench is available whole.
No, asa to time.
They can have that.
Oh,
if you continue,
23, 30.
30. 30.
31, 31.
okay.
Try to take out something more.
My lord.
No, I couldn't get actually. I was
Actually, the last judgment is
Only on 152 I got, but not on 362.
Something helpful so that
Yes,
Mm.
we can close it.
close it. madam.
That is what.
Some handling is required.
And this also bars.
There, yes.
Because.
Yes.
Obliged.